Might just want to restate that once we go live.
We're
Okay.
live.
Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Under the Bagley-Keene Open Meeting Act, remote members of the committee must be visible on the camera, unless such appearance would be technologically impracticable. If so, the member should announce the reasons for their non-appearance during the roll call. Remote members also must disclose any individual aged 18 or older that is in the room with them. Karen, can you please take the roll?
Sure. Ali,
Present.
Brown. Brown not present. Shivers.
Here.
Coleman.
Here.
Guzman. Guzman not present. Joyce.
Present.
Mad Watkins.
Present, and my husband may be walking in the background, so you may be able to hear.
Mercado.
Present.
Mohebi. Mohebi not present. O'Reilly.
Here.
Perlman. Perlman not present. Poindexter. Poindexter not present. Riley.
Present.
Thank you.
Okay, thank you. Next on the agenda is the call for public comment. We are going to take public comments related to asset forfeiture and that working group, which is our first agenda item. It's been moved up to be first. We're going to take public comments related to those issues at the time we talk to the working group. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, COPRAC's work includes drafting advisory opinions on issues of professional ethics based on questions submitted to the committee or developed by the committee on its own initiative, drafting fee arbitration advisories, providing guidance to fee arbitrators, administering attorney-client fee disputes, conducting studies and providing advice to the board on professional responsibility, and studying and recommended changes to the rules of professional conduct. This committee sponsors educational and outreach programs. We do not have authority over attorney discipline matters. State bar staff will attempt to call members of the public in the order that they appear in the attendee pool.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and State Bar staff will call on you in the order that hands are received. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will verbally be alerted once you have 30 seconds remaining. I'll go in the order the hands are received. Kai, you are first. You have 3 minutes to talk.
Good morning. My name is Kai On from Sacramento. For the last 2 meetings, I have talked about Sacramento DA office provide me a fake defendant, Jung So Fong, that hit and run kill my father, Woon Kong On. DA case number 99F08735. I filed complaint Attorney General Mr. Robert Bronter and DA Mr. Tienho because they did not investigate. I report the incident to their office since January 2024, almost 2 years ago. They have never taken action. Also, State Bar closed my complaint against Mr. Bronter and Mr. Tienho without any investigation. I have requested State Bar to conduct an internal investigation about who closed my complaint, but it didn't happen. It seems State Bar is helping to cover up a Sacramento law enforcement scandal 26 years ago. Also, Sacramento City Council even used a UC Davis internship student to email me a fake police report. I went to UC Davis dean office, law school dean office to submit a letter and to email that to the dean. However, the UC Davis Law School also have no response. It seems there's some power is trying to cover up some illegal activity 26 years ago, includes state bar. All committee members, you serve the state bar is to keep a healthy and integrity legal system in California. However, there's some misconduct activity happening in state bar. I appealed all committee members can discuss with other committee in state bar and help to address the issue to the public. Let the public know about this incident. Also,
Seconds remaining.
also I have emailed the evidence to all the committee members 2 days ago. I'm not sure if all of the committee members had chance to read it. Chair, Mr. O'Reilly, do you have any comment about this incident? Mr. O'Reilly?
Your public comment time is up. Please wrap it up. Thank you for your public comment, Kaya. Up next is Audit LA. Audit LA, you have 3 minutes.
Good morning. I know you're not able to handle individual attorney discipline matters, but so I want to make it a broader scope and talk about the ethics or the behaviors and, creating rules or creating more, what you can do to help prevent or to help victims of certain lawyers. I personally am dealing with Kendrick Moxon. He is his firm is a captured firm for the Church of Scientology. He was an unindicted co-conspirator in Operation Snow White. And he's been part of a massive amount of fraudulent cases, using lawfare against any critic or anyone who left Scientology not in good terms. I am an advocate for the victims of Scientology. I speak up for the children who grew up in it, who have left, and who are still living a life of PTSD from their experiences. And this attorney who is he is trying to destroy me. He's allowing because he's the attorney for them, he's allowing them to go after me in ways that are extreme slander and defamation, absolutely untrue, trying to intimidate me from speaking up against the abuses of Scientology. And I ran into him, in the street, and and I asked him, like, don't you know, like, this is slander, it's slander. They but they don't care, because they know I don't have the ability to sue them, really. Like, they could keep me in court forever, but they are torturing not only me, I've had other victims, like the victim of Danny Match, and other people who come and say they too are being tortured by and terrified and terrorized. For anyone that speaks up or goes to the police about them or anything, there has to be a way in the with the bar, because I've made complaints against him, and I keep saying, getting back that it doesn't rise to the occasion that we can intervene. Well, it needs to be. He's an attorney who is using his law license to terrorize people. I am an absolute victim of him. And there's nothing the bar can do because you don't have the proper laws or the proper procedures set in place. Because I get it, you're not used to dealing with maniacal people like this, who have been doing this for decades, who part of the, is that what, I'm sorry?
Your time is up. Please wrap it up.
Oh, thank you. Yes, no, so thank you. So please consider making laws that you can help victims of when lawyers go rogue like that. Thank you.
Thank you for your public comment. There are no more public comments.
Okay, thanks. We'll defer the public comments on the asset forfeiture working group to the time we address that. Karen, would you identify the member? Oh, sorry, we're moving past that. So let's move on to approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes? If not, may I have a motion and a second to approve those?
I'll move to approve.
Second, who's going to second? Aaron seconds.
Aaron?
Okay, Karen, can you call the roll?
Yes. Ali?
Abstain. I was not there.
Brown? Coleman?
Yes.
Guzman? Joyce?
Approve.
Mad Watkins?
Approve.
Mercado?
Approve.
Mohebi?
Abstain.
Perlman?
Approve.
Poindexter? Riley?
Approve.
O'Reilly?
Approved.
7 yeses to abstain. The motion carries.
Okay, thank you. Next on the agenda is my chair's report. I would start by just highlighting some of the work that we've completed this year, which is worth noting as we sort of consider our work plan for the new year. We published an ethics alert regarding activities that threaten the safety of judges and judicial officers. We held the annual ethics symposium, offering attendees up to 5 hours of CLE credit. Proposed changes to Rule 8.2 and 8.4 regarding threats to the judiciary. Proposed changes to solicitation under 7.3, aimed at stopping pre-service solicitation in domestic violence restraining orders. Establish internal procedures and protocols regarding opinions and ethics alerts to provide additional guidance and structure to facilitate the committee's work. We encourage members to start thinking about the status of current opinions and projects and where they will fit in to the 2026 work plan as we proceed with today's meeting, keeping in mind that any required public comment period in the Board of Trustees meeting schedule, when we do something, we have to time it so that the Board of Trustees have the appropriate amount of time to approve it or consider it at their trustees meeting. Rachel circulated our adopted topic prioritization and work format, schedules, and opinion process. As we move through today's agenda items, we'll ask each working group to identify the lead drafter, editor, and scheduler for the opinions you're working on. For opinions started in October, we are also going to be tracking progress according to the goal timeline that we discussed in that plan and adopted. Finally, regarding the 26 work plan, civility and AI are priorities at the request of the California Supreme Court, and we do not yet have set action items or deadline for those items. We'll need to keep in mind that when we're looking at the 26 work plan, we also need to preserve some committee bandwidth for those two and any emergent issues that come up in 26, as they sometimes do. Examples of those would be the judicial threats and domestic violence issues that came up last year that we addressed. Okay, next up is the staff report, and Rachel, can you present that, please?
Yes, hi. I will turn my camera on so you guys can actually see me. I will echo all of Dan's comments and just kind of add on to them a little bit. In terms of the work plan, I just wanted to talk to the committee a little bit about the process that all of the items go through after you guys vote them out to the Board of Trustees. So once they are voted out to the Board of Trustees, staff at the State Bar prepares the memorandum for the board, the PowerPoint presentation. And so we have deadlines because the board also has to abide by Bagley-Keene. So our deadlines for getting all of that in are generally around 40 to 30 days prior to the board meeting. So that's another thing to just kind of keep in mind when we are setting deadlines for next year. When things go to the board, staff will present at the board meeting. We will respond to any oral public comments that are given at the board meeting if we need to. And then we answer any questions from the board members themselves that may have, questions about particular items or things that we are putting forward. And then if the item requires public comment via the Board of Trustees, staff coordinates that as well, and then prepares a new presentation and gets all the new information based on the public comment together and presents at the next board meeting. So it is quite a process, even after it leaves COPRAC's hands, to get things kind of through the system. But when we are talking about our deadlines, we are talking about deadlines to get things out to the Board of Trustees. And then when we are working on ethics opinions, those end with board approval. If it is rules of professional conduct, then those have to go up to the California Supreme Court and get their approval as well. And our Office of General Counsel at the State Bar helps with that process. So I just wanted to give a quick overview of that so that you guys are just kind of aware of how things function after they are voted out from COPRAC. And the board is only meeting 4 times next year, which also kind of complicates our deadlines. So we did include both the COPRAC meeting schedule and the board meeting schedule, along with the draft 2026 work plan, to kind of help us finalize and figure out those deadlines. Second, we as in the State Bar, is looking for a volunteer to help review the civility toolkit that we are currently developing. That is an update to the civility toolbox that is currently on the State Bar's website. So we're updating it and refreshing it given the September orders that came down from the Supreme Court regarding civility. So if anyone is interested in assisting with a review of that, that toolkit, please reach out and let me know. And then I also wanted to provide an update. 3 of the 4 2025 Ethics Symposium videos are officially uploaded to the State Bar e-learning portal, and those are available for self-study credit, and we already have people taking those self-study classes, so that is very exciting, and we are working on getting the 4th one up there as well. And then we have one opinion that is currently out for public comment, 20-0003 on flat fees and termination. We've received about 6 comments so far. In general, the comments are supportive of the opinion, and several commenters provided written substantive comments, so staff will be incorporating those and sending it along to the work group after the public comment period ends on 12/11 next week. And then finally, we had 2 items that went to the board in their November meeting. The first one was 8.2 and 8.4, codifying some of the case law regarding judicial threats and judicial security. And then we had the proposed amendments to solicitation 7.3. Both of those were adopted by the board and are being sent to the California Supreme Court for their review and hopefully approval. And so the General Counsel's office is preparing the necessary documents to move that up the chain. And I did just want to report back that the board reception to both of those items was very positive. I think that they were really happy to see COPRAC's quick action on those 2 issues, particularly the 7.3 issue. Due to the risk to the public that current practice can pose. And I just wanted to share that Tony, I think, would enact that change immediately if he could. And there was very strong support across the board. So I just wanted to report that back. And that is it from me.
Okay, great. Thank you, Rachel. It's good to hear. We're going to start with the agenda items and the reports from the working group. As I mentioned, we're going to take number 7 first in order, which is item 410, discussion of the ethics alert related to the district attorney asset forfeiture and client trust accounting issues. We'll start with the public comment related to that issue.
Yeah, go ahead.
There may be some colleagues of mine appearing remotely who wish to offer public comment. Perhaps we can have them raise their hand remotely and start with them.
Can you confirm?
William Lee.
I don't have their name on here. It's like not related to the issue.
As long as it's related to this agenda item, the chair has authorized public comment on that. So anyone that is raising their hands, we can take public comment as long as it's related to the DA ethics alert.
Okay. So guest 323-89813, you have 3 minutes to talk.
Hi there. I was calling for public comment and I just got in because I was trying to call on the Zoom to give my public comment and I heard everybody talking and I was waiting to get called and nobody called me. So now I called in again and I've been listening to all the agenda items, but now I need to say my public comment or at least connect it to this agenda item because I'm feeling feared by Kendrick Moxon, the lawyer of Scientology who keeps attacking all the protesters and my family. So where do I put my public comment now? This wasn't working on the board.
Go ahead.
Okay, so Kendrick Moxon, I've already written a report. I don't know what to do anymore. I'm addressing the board for the 3rd time because Kendrick Moxon is currently putting people right now into Los Angeles and Clearwater lawsuits of children and ex-members of the cult that are speaking out about his crimes. Today is Lisa McPherson's birthday, December 5th. Her death birthday from Scientology. She was neglected. Kendrick Moxon was the lawyer, the fraud lawyer, falsifying documents that lied about her death, that lied about what time she left, where she was cared for, what was going on. Kendrick Moxon is attacking my family members, people that were inside Scientology that have left, myself. He's trying to get anybody arrested on fake ROs. He had somebody arrested in Clearwater, which has nothing to do with Los Angeles, but he used to be there. That's protesting Lisa McPherson's death. And here he is trying to put me in jail after I was a born and raised child in the cult whose family member is still all in the Sea Organ in Scientology and they're stuck. And I used to be a minor working under Kendrick Moxon, burning and shredding papers that had information that was legal evidence. And here you have Kendrick Moxon putting people in jail that are exposing their families' disconnection from Scientology. This is insane. When will Kendrick Moxon be disbarred? He's been abusing and still abusing his license in every state. And we are the children, the kids that are trying to speak out about it now, and he's attacking us legally. So please take this comment and please do something about Kendrick Moxon's law license. He needs to be investigated now.
Thank you for your public comment.
Okay, just a reminder to everyone that this committee does not have authority over attorney discipline matters. We're going to turn to public comment related solely to the asset forfeiture agenda item, please.
Okay, next public comment from Bill. You have 3 minutes for your public comment.
Good morning. I hope you can hear me.
We can.
Thank you. My name is William Lee. I'm with the San Bernardino County District Attorney's Office. I appreciate this opportunity to briefly speak about this topic. I oversee a number of units in my office, including asset forfeiture, that handle or sometimes come into possession of U.S. currency. So this is an issue very important to me. And in the creation of these rules, I just wanted to ensure that everybody on this committee had some insight into what we have to go through to try to comply with it and some of the difficulties involved. For instance, for non-IOLTA account, whenever we have to create one for my office, the process requires us to gain Board of Supervisors approval for each bank account. So that usually requires that we create a resolution for the board. It has to be reviewed and approved by county council, reviewed and approved by risk management. And I'm sure it probably gets sent up to the CEO of the county for final approval. And then it has to be placed on the agenda for the Board of Supervisors who meet generally twice a month. So just to create an account, it's a 30 to 60-day process. And my understanding is that that's what we would have to go through to create bank accounts. And my understanding is that whenever we come into possession of money that would be entrusted money, we have to create a separate account for each individual. And that is a very difficult thing to do. For instance, if assuming asset forfeiture applied, and I will admit to you, the asset forfeiture issue is not a big issue for my county because we stopped holding on to the money many years ago. Now our police agencies will hold on to it, but we used to place it into the county treasury probably 4 or 5 years ago. So that's not as big an issue, but if it were, we would be creating 50 to 100 accounts every year just to comply with these rules. But in addition to asset forfeiture, it's a lot broader because I also supervise units in my office that have investigators who actually arrest people, execute search warrants during which we may come into cash that we need to seize. They could be hundreds of dollars, thousands of dollars, tens of thousands of dollars. And of course, that would be money that could be entrusted to us for which we would have to create bank accounts. Now, admittedly, it doesn't happen very regularly, but every time it does, we would have to go through this entire process that could last 30 to 60 days to create a bank account just to comply with these rules. And of course, in one search warrant, if we take money that could be the property of 3 or 4 people, we would have to create 3 or 4 separate accounts for them just to ensure we don't commingle them. So I just wanted to relate kind of the process we have to go through, at least in San Bernardino County, to comply with these rules to make sure that the members of this committee and others who are involved in the decision making understand that it's not so easy for us as probably private law firms would be able to do it. So thank you very much.
Thank you for your public comment. We have public comment in person.
Yes, good morning, and I'd like to thank the committee again for hearing from us and other district attorneys. My name is Steve Spinell. I'm a deputy district attorney with the County of San Diego. I know I have limited time. I'd just like to highlight 3 points, one of which I alluded to at the last meeting that I attended in person, and that's with regard to State Bar Rule 2.5 CTAP reporting requirements. Rule 2.5A2 requires annual account registration, bank name and other banking information, and the full name and license number of the designated licensee. Subdivision E is entitled Designated Licensee Duties and states that the designated licensee shall be the primary account holder or signatory on the trust account and shall be responsible for performing or supervising the monthly reconciliation of the trust account. Now, a point I made last time, but I think it illustrates why CTAP simply cannot apply to asset forfeiture accounts held at the county level. We, as the deputy district attorneys up to the district attorney, him or herself, simply do not receive or hold monies that are deposited into an asset forfeiture account maintained by the county treasurer. No one in our office is a signatory. No licensee has the ability to supervise the monthly reconciliation of the trust account. We are not the primary account holder. So we wouldn't even be able to execute this primary function of the reporting requirement, and that is the registration of the accounts. But regardless of how asset forfeiture accounts are maintained, county treasurer level or otherwise, CTAP, in our view, just simply does not apply. It applies only to client trust accounts, CTAs, and we all agree that district attorneys do not have clients, and so by extension, we don't have client trust accounts. Rule 1.15 of the Rules of Professional Conduct requires a deposit of all funds received or held by a licensee for the benefit of a client or other person to whom the lawyer owes a contractual, statutory, or other duty. But a point that we've made in some of the writings that we submitted to the committee is that always the other person arises within the context of an existing attorney-client relationship. We don't have clients. So the classic examples are a lien, which is held by a third party on client funds on trust with a licensee. A licensee who accepts the duty of acting as an escrow agent during the course of client representation. The State Bar's Handbook on Client Trust Account recognizes this. The comments to Rule 1.15 recognize this. So the Supreme Court enacted Rule 9.85, directing the State Bar to establish CTAP to protect client funds and deter client trust mismanagement. The concept of attorneys having a duty to third parties has been recognized since 1963 by the earliest case law I was able to find. Let me then, I'm told that my time is up, but let me shift then just to the final point, if I may. There are no complaints of which we are aware that there has been asset forfeiture account mismanagement, that there's somehow been any type of complaint with regard to that. Contrast that with client trust accounts for which there are tens of thousands of complaints. This is a solution that is in search of a problem that does not exist. And I think that is obvious to the committee to some degree, because I recall the first time that we discussed, someone asked, why are we here? And I think that rhetorical question is well placed. I will submit and invite any questions that the committee may have. Thank you.
Sure. My name is Gloria Morena from LA County Asset Forfeiture Unit. I've been listening into these meetings since September, and at the last meeting, one of you said, it feels like we are in deep waters. And it's interesting that this issue has been discussed by this committee, and the committee has put in the work since back in July of 2024, as I understand. And though we certainly appreciate the time and consideration the committee is taking, but the issue remains murky. Nonetheless, we're still in murky, deep waters. And why is that? Is because it seems that by making the DA's office open up or deem these accounts to be either IOLTA or non-IOLTA, it just doesn't fit. There's a lot of practical considerations and a lot of issues that arise from this proposal. First, the money is not seized voluntarily. The money is seized by law enforcement involuntarily. So when you have the language in the IOLTA that says the money that is entrusted to the licensee, it just doesn't fit. This is involuntary seizure of funds that is subject to criminal law, probable cause, and also subject to the court's jurisdiction. This money is not under our jurisdiction, the licensee. It's under the court's jurisdiction. We cannot touch this money without a court order. And so when the concern of CTAP is that without CTAP reporting, forfeiture funds could fall into a compliance gray area, that's simply not the case, because we have to comply by black and white statute as to how we handle these funds and what we do with these funds and how do we distribute these funds. We are subject to reporting to the Department of Justice, to our Board of Supervisors, to the court. Okay? So that is not the same as a private client trust account. It just isn't. And not to mention the practical issues of having to, if we're going to deem these to be non-IOLTA accounts, to expect the large counties that handle hundreds and thousands of these cases to open up individual bank accounts and close them for each case and each person whose the funds were taken from. That's just impractical. And lastly, do I have time? The characterization of the money doesn't change. It's seized by the law enforcement agency and then turned over to a county treasury. It still seized funds. It's still taken involuntarily. We are not holding it in the interest of the person or an individual. We're holding it in REM jurisdiction. So I just hope that in this discussion of whether, what came first, the egg or the chicken or the egg, that we understand that we just can't make this deem these accounts to be IOTA or non-IOTA just by a snap of a finger. And I thank you for your time and consideration.
Chair, we have another online public comment for this item. Emily Hickok, you have 3 minutes to speak.
Thank you. Can you hear me?
Yes, we can hear you.
Okay, great. Thanks so much. My name is Emily Hickok. I'm a Chief Deputy District Attorney in the Monterey County District Attorney's Office. We're a mid-sized district attorney's office, a little bit different than the larger offices in that we handle asset forfeiture funds in one of the following two ways. Most often when local agencies seize the funds, those local police agencies hold the funds until we have an order of forfeiture, at which point they transfer the funds to us and we help facilitate the proper distribution of those funds under statute. There are also circumstances where all our district attorney investigators will seize funds directly as peace officers. And in that case, we might also hold those funds for a limited amount of time while a case is being litigated. I just wanted to highlight, I don't want to repeat what comments have already said, but I wanted to highlight that again, these funds are seized under the jurisdiction of the court. The court is exercising jurisdiction over these assets in an in rem fashion. We are required to personally notify the person from whom the property is taken and provide them with a claim form. We're also required to publish 3 times to the world that these assets have been taken and forfeiture is sought against them. We can only forfeit the money if we have a court order, which again is a public document. These are not secret settlements that any potential claimant or any other member of the public would not have visibility into. We're required to report to the Department of Justice, and we're required to keep detailed records regarding these funds. Moreover, because this is an in rem action, the claimant is not the owner of the property. It would be completely inappropriate for us to open an account in the name of someone that we're claiming no longer has an interest in the money because it's illicit funds. These funds are similar to all evidence held by either a law enforcement agency or a DA's office. We seize computers, electronic equipment, physical evidence all the time, and fulfill our duties with respect to that property. People have recourse against the county if anything were to happen with their money or property, just like any type of property that was seized in relation to a criminal case. So this is just very different than any sort of client funds. And if the committee were to adopt a rule that creates an obligation to comply with CTAP, we would simply be excluded from the process. We couldn't. For the reasons described, it would be impractical and impossible to open accounts in the way that we're required to do. We can't hold them as IOLTA accounts because the interest is required to be paid to any claimant or to be distributed if ultimately forfeited. And so we're hopeful that the committee will look at this issue and adopt a rule that makes sense in light of the practicalities of this process. Thank you.
Thank you for your public comment. Chair, there are no comments.
All right, thank you all for your public comments. I can tell you from my own personal experience being in this working group that the group has made a very deep dive into this issue. So let's turn to the group now, and I'll turn it over to Cassidy, who's the lead drafter.
Thanks, Dan. So yeah, I echo what Dan just said, is that we met, the working group met. It was me, Dan, Aaron, and Carrie. And we really did focus on this issue of the IOLTA versus non-IOLTA and the fact that it's frustrating, to put it mildly, and probably impossible to use segregated accounts in these asset forfeiture matters, and the IOLTA an IALTA account doesn't really work as well. And so we looked at the Business and Professions Code that sets up the IALTA scheme and whether or not it's inconsistent with the Health and Safety Code that governs the asset forfeiture scheme or procedure. And so we talked about it, and then I'm actually going to turn it over to Aaron, who did the legwork on drafting a draft memo. I don't know if it's final right now, but I think it makes sense to talk about it. I looked at the Carroll case that talks about the underlying, talks about the purpose of the IALTA scheme. And then Aaron took it from there. So I will turn it over to Aaron to take it from here and talk about what your conclusions were. But just generally, I think we all are in agreement with the public speakers that it doesn't work to apply the IALTA scheme to this, asset forfeiture situation. So go ahead, Aaron.
I would agree with that 100%, that I think that the working group has come to a consensus that the CTAP procedure more broadly, Rule 1.15 does not apply, as the public speakers have all identified, with assets that have been involuntarily seized from potential criminals in a criminal investigation, whether they're held by the county or in some of the smaller counties or mid-sized counties like Monterey, where the asset forfeiture account, which is maintained by the county or DA's office directly, those type of accounts are not subject to Rule 1.15, and because they're not the same as the entrusted funds that a lawyer would be holding in the course of either, advanced deposits in an hourly situation or settlement funds, and the idea of distributing contingency fees. So the Health and Safety Code itself requires that the funds be maintained in an account which has to have interest, which gains interest, which obviously is anathema to IALTA accounts. And under Carroll and under Business and Professions Code 6211, there really are only two types of trust accounts for lawyers in California. It is inappropriate to try to use a general account other than an IALTA. And I don't believe it's even accepted. After January 1st, I don't think you could even open one in California that way, because now a licensee has to be tagged with that account directly. So I do think that we're going to be able to work on an advisory which should satisfy the concerns, which are well taken from all of our public speakers.
Okay, thank you, Aaron. And can you just give us a sense? I mean, I'm in the working group, but can you just give us a sense of the status? There's a draft of a revised alert to that effect, and what do we think the timing will be? The working group will meet again to revise.
You have to get another date. I did put together a revised alert, obviously, very different. Yeah. I think we can get it done pretty quickly, because I drafted it, so of course I would have the thought that it's close, but I may not be right. I don't think it's going to take too difficult. I think we can probably get our draft done. I mean, we're up against the holidays here, so depending on when we meet again, I think one more working group meeting should get us a draft that can come to the whole committee.
Yeah, I would agree. I would agree with that, because what you drafted, Aaron, is pretty complete. It just, we haven't had a chance to digest it and meet about it. So it's really, just that piece of it. So we're not waiting on drafting, I don't think.
Emil.
So when's our next meeting? Oh, sorry. Yeah, Emil.
So I'm not on the working group, but I think I have a question about where we are. So in September, I have the draft from September, and it seems to go through the Health and Safety Code, Rule 1.15, and then kind of leaves the question that 1.15 may apply to asset forfeiture. So I think there's a few options here. One, you continue on that path, which doesn't seem like the working group wants to do. Two is to simply not put out an ethics alert. And the third option seems to be what you all are talking about, which is to put out an ethics alert. But I guess I'm unclear. Would it say that 1.15 does not apply?
Yeah, that's exactly right. It's going to be, let us ally all these concerns and all these people that are up in arms in this idea In fact, we don't believe that. We think that the statutory scheme provided in the Health and Safety Code for these asset forfeiture accounts makes it very clear that Rule 1.15 and CTAP does not apply to these type of accounts. That's what the ethics will be saying.
I see. And I want to just kind of address the amalgamation of the comments that I heard. I guess in some cases, some people were talking about IOLTA accounts, some people were talking about CTAs. This is the same analysis that every law firm has to do. Do we need to put it into an IOLTA account or a CTA? So as somebody that currently represents firms that are going through the CTAP process, it is a very laborious process, right? And the designated attorney, all that's a new thing that's come about. And I think it speaks to how the CTAP process came about. The idea is client protection, but we know it's just a reaction to the Girardi thing. So I'm torn about this issue. I'm not going to say one side or another. I am aware of news articles that talk about asset forfeiture and how certain people get pulled over, get their cash proceeds taken, affecting a lot of minorities, and they end up being in a position where they cannot deal with the justice system to get their money back. So I am, concerned that we're taking away and potentially making a statement saying, yeah, we don't think that the trust account rules or CTAP protections may apply. I'm not an expert in asset forfeiture, so I can't speak to whether the current protections are sufficient, and it's just an aspect of what just some people don't know. But I just want to address the fact that I think that it would be helpful if maybe district attorney's office looked to say, no, I'm not giving the police or the law enforcement, we're not just passing the buck off to them, that we will monitor it. Because I think at the September meeting, the speakers that did speak did say, hey, we go through a process with the Treasury. No one, no single DA can just withdraw funds. We wait for a court order. We have this, process in place. But if we're saying CTAP doesn't apply, you don't have to worry about these things, then theoretically a DA's office could say, we're just going to leave it with the local police department. And we have no recourse, because if the police department loses it, or if a county or city goes through bankruptcy, that maybe the individual whose funds were taken or seized, may be out of luck. So I know that's a lot to say. I was just trying to address quite a few different issues.
Cassidy.
Yeah, I mean, I think on that front, whether or not we're just ignoring or saying that protections don't apply, that's not what we're saying. We're saying there's just a different scheme that applies to asset forfeiture, and it's under the Health and Safety Code. And I don't have it in front of me, but the Health and Safety Code section says that it has to be, proper accounting measures have to be followed. So, and it sounds like that is what's happening, based on what the public speakers have said. So, what we would be doing, I think, if we were to impose, 1.15 and the Business and Professions Code, is a whole other layer of requirements that make no sense. So, that's the idea here. It's not, we're taking away a layer of protection.
I think that's right. The issue is the CTAP rules related to reporting would not provide a remedy for the issue that you just described, because somebody, whoever it was, even a licensee who was in charge, but would still have to disperse only pursuant to a court order. So if you are somebody who has a claim to those funds, that's your remedy. And that is the procedure that would still be required, even if there was some layering of the CTAP reporting requirements. Allison. Go ahead.
Hi. So I get that you're going to write a report saying that it doesn't apply. What about the actual verbiage of the rule that started this whole sort of process in the first place of other responsibilities? Is that going to be specifically addressed, or does there need to be a comment added that carves this out as other things for the police or DA's office as sometimes does, so that it doesn't come up again in a few years or anything like that?
Yeah, that's a good question. Yes. Sorry, Erin, go ahead.
I was going to say, I don't think it's going to come up again in a few years, because I think once the ethics alert goes out and there's been a determination. Well, I think that what we plan on putting out will make it very clear that the rule on its face does not apply to this type of an account or this type of fund.
And I like, so this is just a half thought, but one of the speakers said, did address the other person language, and that it was, that is all arises from an attorney-client relationship. And I think we might need to drill down on that a little bit more in the alert. So that might be some additional drafting and analysis that we should button up on that particular front.
I think that's right, because that is part of the rule text that opened the door to this in the first place.
Yeah.
A novella.
Yeah, I agree with Allison. I thought the other person, and I guess Cassidy as well, the other person language in the rule seemed to be the source of the confusion, and the public comment about the other person arising from the attorney-client relationship, I think is clearly responsive to that. And then I was also looking at the I guess the old version of the rule where it went from by a client to by a client or other person. And it does look like the other person part sort of snuck in, but based on the comment that it had a much more limited scope, like it's not any other person, it seemed like it was tied to a specific example. And then I also think the public comment about the word trust, that like in the trust account context that it's voluntary, and in the asset forfeiture context it is not voluntary. Like I think that distinction also seems relevant to why there are different rules being applied in each situation.
Okay, let's come back to just with staff, just getting a sense of the working group is going to consider this and revise this draft that Aaron's created. We're going to look at the other person issue in more detail. We have started doing that. And then we'll have a revised draft for the committee to consider and approve by our January meeting. But can we hear from staff whether that is going to work in terms of this new season coming of reporting?
Yeah, I think that timing would work. I think the bigger issue is making sure that whatever alert we're putting out has the applicable and appropriate authority to support it, because I'm a little concerned that this conversation feels like it is being driven by a desired outcome versus an analysis of the current state of the law and case law. And I think that we just need to be really, really mindful that whatever conclusion we are coming to needs to be supported by the rules, the comments, the legislative history, case law, whatever is out there. And if we don't agree with the conclusion based on the current state of the law, then we would need to consider a rule change. I think with this ethics alert, especially, our last ethics alert on judicial threats ended up having accompanying rule changes with that. And those rule changes are going to be going up to the California Supreme Court for review. As part of that, the Supreme Court will most likely be looking at our ethics alert that was issued on that. So even though we aren't going through those multiple layers of approval that we do for advisory opinions or for rules, I think there is a very good chance that eventually either the board and or the Supreme Court would be taking a look at this ethics alert. And so we need to make sure that it is 100% backed by the current state of the law. And if it's not, then I suggest that we kind of pivot and look towards potential rule changes or adding comments for clarification, especially just given the recent history of the state bar taking things up to the Supreme Court and then being denied. And that includes, the recent rules of professional conduct that COPRAC put forth with respect to civility and trying to add civility to the rules of professional conduct. So I think my concern in this conversation is I am not hearing the legal authority to support these conclusions. And if we can get it, great. But I think that that really needs to be the focus of moving forward with this second draft.
I mean, I agree with that, except that was the point of our last working group, or what came out of our last working group was to find that authority. And I think between Aaron and I, we did do that, and we will continue to do that. The problem is with a lot of these, and why we're here is that the law is not clear. There's a hole here, there's two different schemes, and we were trying, we're looking at them, and there's no case that interprets them together. So, we have to make some logical leaps. So yeah, I mean, I really appreciate that, Rachel. But that is our task with the working group, is to find that authority. And if it ends up that we're going to come to the next meeting with, I think we also need to propose comments, or some kind of rule change, then, we'll talk about that at the next working group meeting. Because that might be, I still think that might be a good proposal, which has always been on the table, at least in my mind.
It has been part of the working group's consideration about whether a rule change or a comment would be appropriate based on the conclusion. Yeah. Okay. If the timing for the next meeting works, I think this working group will meet again, revise the draft, and have something to present to the broader committee. Obviously with staff's input as part of that as well. Okay.
Can I just ask a quick, do we have the legislative history? Is there any indication in the legislative history it was intended to cover asset forfeiture?
For asset forfeiture, you mean under the health and safety code or the BMP code? Like whether or not, yeah, I mean, I can't remember if I actually looked at it, but I don't think I don't think it talks about asset forfeiture. Like this issue I don't think was ever contemplated on either side. I don't think the health and safety code, the legislature was considering the BMP code when it was drafting the health and safety code, and vice versa. So, but yeah, we'll take we'll take a look at it more closely. But I think
commenters gave us some interesting sort of plain language arguments to consider if there isn't inconsistent legislative history. I found some of them persuasive.
Okay.
Yep.
I just want to flag the problem here is that they're not inconsistent. It's just that compliance with it would be entirely onerous and not add anything to public protection. So that's what the working group is struggling with, is that even though there are these two different schemes, their compliance with both, they're not inconsistent with each other. It just doesn't seem to be achieving the means that either are intending.
But there's different purposes, like for BMP code, it's client protection. There's the tax issue, and then with the health and safety code, it's not client protection at all. There is no client, but it's.
But my point is compliance with both is not inconsistent. Even if they are achieving two different means, that compliance with both is not impossible or inconsistent, which is why I have been saying that a rule change would probably be the most elegant solution here. But we will reconvene and continue to talk about it.
And sorry to interject.
Yeah.
That
I
rule
was
change.
say I agree, Carrie. I mean, I agree with Carrie there. Right. Sorry. Go ahead, Emil.
The rule change would be to 1.15 to clarify, or maybe a comment to clarify that. Okay.
And I was saying that, one of the fastest things COPRAC has achieved this year was a rule change. So I know that we're all hesitant to do it because it's like, well, if we do this one change here, then what happens in 2 years when some other discrete insular issue pops up? But I think that we shouldn't let that necessarily get in the way of doing good work now. So,
well, and I think that's Rachel's point to some extent, which is like the fact that it's impractical is not in and of itself enough. So it may require a new comment or a rule change. Emil?
Can I make a suggestion that maybe, sorry to put more work on your plate, Rachel, but maybe staff can give us the legislative history from the model rules about 1.15, and if 1.15 can be interpreted to apply to non-client funds in the government context. Maybe there's another jurisdiction that's kind of looked at this, or it could be in the ABA history. I doubt it, but it might be something to look at to point us into the right. So, because maybe without getting a comment, without changing the rule, it might be self-apparent there.
Yeah, that's a great idea. We can have staff do that research, no problem.
Okay, if anybody else has contributions, please reach out to the working group. We'd be happy to have any more ideas that you have offline. And thanks everyone for the public comments related to this issue. It is in progress. We will be back soon with a draft for consideration.
Thank you.
Anything else on this item?
For me.
Okay, let's go back up to the top of the order, and we'll go to item 4.2 is discussion of draft 190004. Client file release and retention duties. This was going to be presented by Mary Grace. She has been excused from attending based on her communications. And so I think what we would like to do here is identify temporarily a redistribution of the assignments in this working group so that another member of the group could take over the lead drafting role while Mary Grace is not doing that for a temporary period of time. So who'd like to volunteer?
This should be, fingers crossed, relatively easy. It came back from public comment, staff incorporated the comment, and at this point, I think we're almost there. We just need someone to kind of review it and come to a consensus on where we want to go.
Okay, somebody on that working group would like to volunteer to take it to the end zone. Vikita, Eleanor, or Emil?
I can go ahead and do that and come back next meeting. Yeah, I'll take care of that.
Okay. For all the working groups, can you communicate to staff the lead drafter and scheduler and editor according to that process that we adopted? And we'll reflect that Emil is going to take over as co-lead on that till Mary Grace is available. Okay, item 4.3 is next. It is 20-001. This is me as lead drafter with Carrie and Vikita and Aaron and Eleanor. And we did meet once or twice at least, and we did also consider public comments. What has emerged, at least in my mind, is that we need to take a little bit more time with this. All of the major bar associations provided public comments, extensive public comments related to this issue. And in the public comments, one of the issues that came up that didn't appear to be controversial, I think, when it was sent out, was whether and to what extent expert witness testimony is the practice of law. Not an easy question to answer, but it's something that we are at least going to address more clearly. But even in the conflict section, because of the volume of public comments that we got, and I've gone through all of them in detail, I think it needs a much more comprehensive revision. This draft dates back to 2020, and it's an example of sort of the perils of drafts that have many, many different authors over periods of time, because we have to go back and freshly look at what the rationales are. And because of the volume of public comments that we got, I think it's the right thing to do to go back and give it a more comprehensive revision so that it makes sense. We have, from the committee's conversation last month, we did decide to do a couple of different things. And one is we're going to clarify that in some instances, the expert witness service may be the practice of law. We're not able to say rule that would mean that it's not. Depends on what you do. But also scenario 3, which was and always has been the most disputed element of this opinion, I think we're going to collapse and condense because it just doesn't seem like it requires as much analysis as the other two. But it needs to be gone through and make sure that it actually holds together and makes sense in light of the public comments. Anybody else from the working group have a thought on that? Hearing none, we will come back at our next meeting before then with the revised draft. Okay. 4.4 is discussion of draft 20-0005 conversion clauses and contingency fee agreements. Also one that's been with us for some time. This is Eleanor.
It has been. So that's Nima, Cassidy, and me, I think is the full group on that now.
And Aaron.
And Aaron, sorry. Yes, Aaron as well. Thank you. I don't think we assigned anyone because we're pretty far along, so we didn't go down the process of assigning people. Cassidy turned the last draft, and then and Nima had comments. I turned it around this morning. So I think we're going to be in a position where we are able to circulate a draft to the committee well in advance of the next meeting and hopefully vote it out at that meeting.
What is this at this point? This is an opinion? This is an alert?
It is an opinion. It is
Okay.
remained an opinion. We had discussed changing it, but ultimately decided that it was important enough that it could be an opinion, and we thought it added enough examples of clauses that would violate ethical obligations that it was worth putting out there as an opinion.
Okay.
I think we could probably, we'll see what the committee thinks, whether or not it thinks it adds enough that it's worthy of an opinion, but I think we all ultimately landed on it. It did.
Okay, so you expect to have a draft of the opinion for the committee to consider in January?
Correct.
Okay. Can you also designate a scheduler and an editor, or just let Rachel know what you decide on that?
Sure, we can do that.
Okay. Anything else on that item? This one's been around for a while, so let's move it if we can.
There's really nothing else on this one. It's very close. We went back through it and we're kind of just.
We've probably talked about this more than any
point.
other one in the last year and a half.
What was that?
I think we probably have considered this one more than any other in the last 18 months.
I think that's right. There were a lot of opinions on all sides here. It's ultimately shaping up as a warning, and list of examples of the things that would violate.
Okay, that sounds good. All right, thanks, Eleanor. Next up is item 4.5, which is 21-003, ethics of in-house counsel, business transactions with clients. This is Cassidy.
Thank you. Okay, so it came back from public comment, and thank you, Nima, for making your comments to the comments. I think the only substantive issue maybe that we need to discuss is the 1.7 analysis about the advanced conflict waiver. Discussion about whether or not lawyer would be required. Can we put this on the screen?
Yes.
Kathy.
This is 21-003.
Yes.
Yeah, and so if you can put the version that I emailed this morning, sorry. I think it was this or yesterday when it went with Nima's comment and with the public comment. Yeah. Okay. So I think the red lines here are fine. The to the client comments. Yeah, so if you that's fine. Just keep going down. So on the 1.7 discussion, the concern was whether or not an advance waiver was required when at the time of the hiring based on the stock option agreement where the if there was a merger it would be accelerated so that maybe the lawyer's interest would there would be a conflict of interest between the lawyer and the company. And I think that, I mean, the question I have is an advance waiver ever required? I mean, isn't it more just sometimes just a good idea to have an advanced waiver? So that was kind of my thought, and that was sort of my thought when I was drafting this is that lawyer may want to have an advance waiver to say, hey, this is what might happen if there is a merger based on this, stock option agreement. But that if there is a merger, you go back and look at what you advised about and whether or not those circumstances have arisen. And if not, then you have to do another conflict waiver. And I thought that was fairly clear in what we wrote, but I think what the Orange County Bar Association was saying is that they want more clarity or a concrete conclusion there that an advance waiver is or is not required. And so I'm just throwing it out to the committee. I mean, I don't think an advance waiver is ever required.
No,
So it's okay to say it's a good idea, like you might want to, and if it's sufficient at the time, it may be sufficient so that a second waiver is not required if it has, specificity. The risk of an advance waiver is it's so vague that it can't apply, it's insufficient. So that's why you always have to revisit it. But so anyway, I invite Nima. Is Nima? I invite Nima to make comments based on his review as well,
Yeah.
or anybody else.
Sorry, could you go down just a little bit on the screen? Yeah. Yeah, my only concern with this was it just seemed like we're putting too much of a burden on in-house folks because we have, like you get consent for the first part, but then you need to get consent if there's a separate thing. I just, I think in the context of incentive awards, I mean, it's typically the case that, a in-house counsel, it'll be part of their initial pay package. So, they'll get an offer for a certain amount of salary. They'll get, here's your stock option plan. And I mean, from my standpoint, like whatever disclosure should be included would be included there if later there's some sort of a change of control event. It just seems weird to have a second disclosure.
A second. So I was going to say, what we would change is to say, like, put a more definitive conclusion as to the facts here to say that there is no conflict waiver required at the outset. But, with anything, if there is a merger, if there's circumstances where the lawyer's interests, financial interests may be at play, and there's a risk that the lawyer could make decisions based on, what they're going to benefit from. You would need a conflict waiver later. So is that inconsistent with your thinking, or am I missing? Are you saying that the disclosures at the outset should be sufficient throughout, even in the event of a merger?
Yeah, I mean, because the scenario that I'm envisioning is I own stock in X company, and I'm the general counsel. Like, let's take let's just use a public example. There's a very high profile entertainment deal announced today, Netflix buying the shares of Warner Brothers stock. Folks that presumably in-house folks that have stock at Warner Brothers, they have a package that they agreed to initially. They have options that vest over a current period of time. So whatever transaction deal or like the terms of how their stock is purchased, sort of the same as all other shareholders. Are we saying that like before that transaction consummates, they need to come back in and say, well, here Warner Brothers is what you're going to have to pay me, and my interest is. I mean, what I'm saying is that when they sign their initial employment documents, it's almost like assumed, like this is what we're giving up, and so I worry that making it too complicated almost creates a situation where we're sort of facilitating potential violations with where folks won't comply.
Okay, well, 1 second, Mel, let me just respond to that, and then Mel, I'll pick on you. I appreciate that, but I mean, and I suppose like the disclosure is gonna have, everybody's gonna assume, yes, you're gonna personally benefit from this, acquisition, right? Just like any other employee, the attorney who has these, stock options. But a lot of things happen in acquisitions and mergers, and the in-house counsel is advising about that, and there could be, like I think one of the comments was, well, what happens if, the legal department gets dissolved, or that their position is different? I mean, I advised an in-house lawyer where that sort of happened, and it was not unusual. Well, there were so many different factors involved in how the acquisition happened, and I don't think it's necessarily predictable at the outset. And so I think it does make sense that you do need to sit down, but when there's merger talks, acquisition talks, the in-house counsel has to evaluate, okay, do I need to do a conflict waiver, since they're going to be looking to me for advice on this?
So maybe that's the trigger, because you could see in a scenario like the one I just mentioned, a significant portion of the in-house department is probably not involved like at all in the merger. So if someone who is handling the merger and stands to benefit from it, all I'm saying is that when traditionally equity compensation packages are like pretty critical to not only just startups, but like all in-house lawyers, because it allows kind of this ability to like make up the compensation gap going from a law firm to in-house, and it creates a way for in-house firms to hire good people. And most of the time, those packages, I would think, are negotiated at the outset. I think what you're saying makes sense if a lawyer is directly involved in the underlying transaction, circumstances change, there might be something different that starts to kick in. And if that's the case, then yes, you would want an additional disclosure, perhaps.
Okay. Emil?
Yeah, Emil.
So I think if I understand it correctly from Nima's example, if a Netflix attorney gets hired, 5 years ago, and he is or she is, being offered stock options as part of a compensation plan, we're suggesting that 1.8.1 applies and that there might be some sort of conflict waiver that's needed for the provision of the stock options. And then that itself, just like we talked about with the DA issue, is more of a practical aspect. It's like maybe the rule does say that, but the practicalities of it just doesn't happen. But this 1.7 issue, I think, is a little bit more nuanced. That person that was there for 5 years, and then all of a sudden today it gets announced that their options or their ownership in the company might change, might be valued more. I don't think that we're saying that needs to be addressed in a conflict waiver, unless I'm mistaken. But I think what we're saying is, for example, if we're working on that merger, and by virtue of us working on that merger, we know that our vesting schedule will accelerate and that could benefit us in a certain way, or that we have some sort of information as we give our advice, that's where the trigger to refresh the conflict. Is that right?
Yeah, I think and I think we need to make that clear here, because I think it's the advising on the transaction itself and how that advice might be impacted by your own personal interest. And it doesn't necessarily have to be just the stock options that would be the primary thing, but it could be like you're standing at the company in the the merger or the acquisition. Yeah,
like
I think that
bonuses.
makes sense.
Yeah, and like there might be
all of that.
a trigger bonus. But then one other thing, because of the 1.8.1 issue, that's the area that I'm a little bit, concerned about. I've heard from clients about this issue. And I think what I might suggest is that we give some sort of maybe practical thoughts, is like, how do you do this? So when the HR person says, here's your offer, right? The hiring manager has spoken to you and they like you. We want to extend an offer of X dollars. And as part of our standard compensation plan, you have a target bonus of this much, which will be included. You can get RSUs or options. Do we then, as we all know, conflict waivers don't always have to be signed, but they should be confirmed in writing. But in this particular instance, do we need to get something signed in under 1.8.1 by the hiring manager, by the HR person? I mean, what are we really suggesting needs to be done here?
So on that, I would say, it could just be sort of standard with the agreement, whether it's in writing or not. Like, as long as the company's on notice of what it means, I think that's sufficient. So, but yeah, we could probably provide some practical guidance, like, here's some language that you could use in making this sort of disclosure, just so folks are aware of it. But I would want to leave it fairly flexible, just to give folks the ability to be able to communicate with the way that they think is most effective and using their professional judgment.
Yeah. And by the way, it does say in the rule that it has to be informed written consent. So technically, needs to be written. That's the the odd part.
My point is, though, is that the written aspect of it, I think you're signing an employment agreement. And so you're disclosing the terms of the employment agreement. And if let's just say in the discussions, you make the disclosure verbally and they're like, yeah, we get that. I mean, maybe that's too flaky, but I like you worry about the actual compliance on this. And I don't want to put something out there where you have a risk of thousands of people having their equity compensation subject to being voided because they didn't include some clause in the original contract.
I don't want that to happen.
Well, but
That
like,
was
but
our
that, but
original
that, but that,
concern.
well, that's what I'm saying. But like, that's like the logical, like, corollary here. If the rule is interpreted to mean that it's not that you have to disclose, and otherwise you're at a bargaining disadvantage, or your client's at a bargaining disadvantage, then you're basically saying that anything that was like any part of like a contingent compensation structure that was negotiated is like void or voidable.
Yeah. Okay. So let's do this then. I think then there's some substantive changes. Is there any more comments on this? Sorry, I didn't mean to cut off the conversation. No.
No, but I'm not sure if it's substantive though. I don't think so. I don't think it's substantive, and maybe Rachel can chime in too. Like that has to go back and go through other public comment. I just think it'd be helpful to just clarify, and maybe through reorganization, or maybe it was just unclear to me about the 1.7. And then just a thought. I'm not going to say that it cannot go up if it doesn't have something about the practical, but it was more about, like, can we put in a sentence there saying, for example, under Rule 1.18, or sorry, 1.8.1, informed written consent could be achieved by email communicate. I'm not sure about the contract, the employment contract, but by a written email communication to the HR person or something.
Yeah, I mean, I don't think that's substantive. I think the 1.7 might be substantive, where we're actually refining when the second disclosure is required. And I think we also need to, I think I want to put in there to say that if there's always the disclosure. Okay, the first conflict waiver is not required under the facts that we have. But I think it's more important to identify when you do need a conflict waiver, if you're advising on the merger itself. And I think that is substantive. So Rachel, what do you think?
Yeah, I agree with that.
Okay.
So we need to go back out for public comment.
Yeah, I mean,
if we're making we're talking about, it sounds like that 1.7 piece is substantive. But obviously it will depend on what it looks like after that, but it sounds like it may be.
Okay, so once we revise it, then we can come back and decide then if it has to go back out for public comment, right?
Yes.
Yep.
Okay, let's do that then.
Eleanor.
Okay.
Yeah, I just had a quick question. I heard part of the conversation we were talking about including a waiver potentially in an employment agreement. I wanted to clarify there is no discussion about the employment agreement itself being subject to the rule, right? Because they're not a client at that stage.
Say that. So the employment agreement itself is not subject to
negotiating your employment agreement at the outset. That would not be subject to the rule because the entity, the employer, is not your client at that stage, right? So we're not.
It is subject. Yeah, but if you are, that's why 1.8.1 applies if you are getting ownership as a share of ownership in the client.
So
I'm sorry?
It would even be because it's part of engaging on the overall. Okay, so all right, that's interesting. Thank you for clarifying it.
Okay, so we'll take it back and make these kind of minor revisions. So I'll deal with the 1.7 discussion. And Nima, do you think you can add on just the practical guidance piece?
Yeah, absolutely.
Okay. Divide and conquer here. Okay, and then we'll come back at the next meeting with the new version, and then we'll decide whether or not it needs to go out for public comment.
Okay. Thank you. Let's just keep moving through. We want to keep to the 12 to 1 lunch so that everybody can kind of rely on it in case you have something scheduled. 4.6 is draft 24-001, Ethics of In-House Counsel, Former Clients IP. This is Emil.
Yes. So we hope to bring this to the meeting next month. Yeah, in terms of we're kind of deciding about putting in some additional like examples, and just going to get the team back together and hopefully get this to you for the next meeting.
Okay. We will also communicate who the scheduler and editor is to Rachel as well when you have a chance. Okay. 4.7, 25-001, attorney adjacent work and handling retainers and fees. This is Cassidy.
Yeah, I dropped the ball on this one, so I don't have anything. I will have something, an outline. Who is on the working group?
I am, and Vikita.
I'll get it together. I don't know exactly. Vikita's not even here today, right? No.
Right. But the stage where you are right now is you're at the opinion outline stage, and just to see if it's what form it may take.
Yeah, I haven't. I know. I have to. I feel like a broken record. I have to get the outline that I did a long time ago and just update it. And so I'll circulate that to you guys, and then we can kind of figure out what to do from there. I don't think we'll get an opinion drafted before the next meeting, but we can present the outline.
It should be the outline. Yeah, I think that's right. Because part of the process is that we would then assess what form it takes.
Right. Okay. I'll get on that.
Maybe an alert. I don't know. Something like that. Maybe not. All right, thanks. 4.10. This is an ethics alert. This is we covered that. That's the asset forfeiture. 4.1, arbitration advisory 9802. And this is novella.
Yeah. So this was a request to update the arbitration advisory about providing reasonable accommodations during mandatory fee arbitrations that the local bar associations handle. So the request was motivated by the fact that the current advisory opinion references forms of reasonable modifications or accommodations that aren't really current, like it references CDs or discs, like things that people don't really use anymore. And then also at the time the initial opinion came out, the arbitrations were done in person. They were in-person arbitrations. And now a lot of the local bar associations have switched to doing remote or video conference arbitrations. And they've also, a lot of them switched to doing statewide panel appointments where the arbitrators don't necessarily live in the same county as the client and attorney who are in the fee dispute. So Raquel and I looked into this in order to update the advisory opinion. And I guess one of the major issues I wanted to flag for the group is that the initial opinion essentially asks, like, are the local bar associations places of public accommodations? Yes, doesn't provide any analysis. And then it goes into, like, given that they are, this is like their options of how they can do this. So in the course of looking at the current case law, the first question isn't going to be just yes. So I wasn't sure if updating the arbitration advisory opinion is still going to be responsive to the initial reason folks requested it, because instead of saying yes, you have to provide reasonable accommodations and modifications, now it's going to be, oh, well, maybe. And then if you do, here are some things you can provide. So one question I have is just, do we still want to keep with this format of what was requested to do an update of the opinion? Like would a alert that says like, given the current times, these are the different ways you can accommodate people in remote arbitration settings, if that would be more appropriate. And I guess one of the reasons tied to that is because the case law is somewhat muddy. So I wasn't sure because of the guidance about doing not just arbitration, but any updates or opinions by our committee. One of the issues is like, is the law well settled? And I think in this instance, it's not. So I don't know how far we want to like go out on a limb in cementing what the law is in answer to the first part of the question, when really the thing that folks were asking for was the second part of the question. And then I guess generally statewide, the rules of court provide like its own reasonable accommodation rule, like it doesn't rely on federal law. So there is sort of a trend in California where we just don't rely on federal law for our civil rights. We treat federal law as the floor, and then like the state legislature, but then also like the state bar and the Judicial Council end up adding their own civil right protections instead of just relying on federal law. So I wasn't sure if the committee, just as like a matter of policy, wants to just say, we want to stick with the floor of the American with Disabilities Act, or if we want to do something policy-wise to address the potential disparity there.
Okay, so the idea would be that an alert would just sort of lay out some of the factors that you would consider if you determined that it did apply.
Yeah, like I think it could do like, a lot of courts or other tribunals provide Zoom hearings, and these are the types of tools that are available in order to accommodate people in the like remote Zoom teleconference era.
Yeah, that does sound more like an alert, more appropriate for an alert. So what does everybody else think? Emil.
If it turns into an alert, does that mean the old one is withdrawn?
The advisory opinion? No, it wouldn't modify that, I don't think.
So then wouldn't we be then stuck with, I mean, I know they're different, but wouldn't it be better than to just update the other one so that there's not kind of confusion?
Couldn't you just say on the old advisory updated by alert? Isn't that what they basically say when they're updated? No? Rachel?
Rachel, would an alert actually update an advisory opinion?
I don't think we've ever done this before as a committee. Yeah. So no, it wouldn't. Both of them would be out there kind of coexisting. I assume there has to be some sort of process for withdrawing one that's been published, but I'd have to look into that.
Well, do they get withdrawn when you issue? Because it does, the advisories say, does it say replaced when you have an updated opinion?
So if we updated it, that would take the place of the old one. But I think part of the issue is that because we don't have a built-in process just in terms of the baggy clean and then the co-proc rules specifically for alerts, so it's a little bit muddy in terms of how that works. I don't think an alert could override an opinion though, because an opinion went through the public comment process, is approved by the board, and the alerts don't do that. So I think just logistically speaking, an alert would not override an existing opinion.
Yeah, that's my thought as well. That would suggest that maybe it just should be revised. What do you think, Novella?
Yeah, I think that makes sense if we want something formal in place.
Well, there's already something formal in place. That's kind of the...
I guess, I mean, the thing that's going to be formal that's in place, it's going to go from yes, you have to provide reasonable accommodations to like probably maybe. So just to give an example of like the irony of the change in law. So before, if you had an all in person setting, then and someone said like, oh, I have a like visual impairment. I want to bring my so typically the arbitrations aren't open to the general public. They're only open to like the people who are participants. So it would be like a reasonable modification or accommodation to allow like a client who has a visual impairment to bring with them someone who is sighted to help them understand what's happening during the proceeding. So that would be, you know, if it were still an in-person situation, that would be a reasonable accommodation that the Bar Association should consider, because under that formulation of the law, they are a place of public accommodation. If you switch to like closer to the current facts, let's say the Bar Association only does remote Zoom teleconferences and arbitrations, and the person makes the same request. They want someone cited to like sit with them during their arbitration so that they can understand what's happening when it's done over Zoom. The answer would be no, like you're not, the local bar association is not a place of public accommodation because the arbitration isn't tied to a physical location. So it doesn't have to allow that person to help them like have access to the Zoom arbitration.
But it could.
It could, yes. But I mean, in the rule, if we were writing this as an opinion, it would be like, no. The answer to the first part is no.
Right. So the update makes it worse.
Yeah.
Well, I mean, then the question is, would the alert just say, we think it's a good idea? To permit to do this?
I mean, it could. That's why I was also asking, like, is there something this committee could do or the state bar can do, like similar to how the rule of courts don't just rely on the American Disability Act. They say like courts have to provide reasonable accommodations under this rule. So in this context, there are minimum state bar guidelines for mandatory fee arbitrations that are run by local bar associations. But I didn't see anything in there that says like it's a good idea or even required to provide reasonable accommodation. So I'm wondering if we want to, if there's anything we can do to change that part of it, so it's not just like a suggestion. I guess I'm also assuming that we want people to have more access.
Yeah, I think that's probably right.
I guess I'm just very surprised by, I didn't realize that, because I guess the way I would think about it is if you're visually impaired and you're going through an online arbitration and somebody puts something on a screen, you need somebody to be, unless you're using some sort of screen reader, you know, having another sighted person to help you is reasonable. But you're saying that.
Yeah, so I'm not saying it's not reasonable. I'm saying that the threshold question of is this entity a place of public accommodation when operating this like Zoom only arbitration program, the answer is no under the rule that courts of appeal in California and some other federal circuits have adopted.
It's interesting. Yeah.
And I mean, I'm putting aside my like dispute with the analysis of like the split between the federal circuits and whether or not it makes sense, and just saying like, this is the rule that these California court appeals have adopted. So if that's the world we're working in, then this is the reality if we're just relying on the ADA.
Okay. And then this goes back to Rachel's point, is we have to look at the analysis of the law, not the end game. Right. So is there, have you thought through, like, is there something, a rule change that we could, because it seems like, just transparently, my personal opinion would be, I would like to see those same protections available in an online arbitration. Is there a rule change that we could look at that would allow that?
Yeah, so I mean that was one of the questions I had for the state bar staff. So there is state bar rules for the mandatory fee arbitration program, but each local bar association doesn't have to adopt those rules. So initially my idea was like, oh, maybe we can change the state bar rules to say that like you shall provide reasonable accommodations and modifications. And then I asked the state bar staff, and the response was like, even those are the like baseline rules. Each local bar association gets to look at those and then say, what do we want our rules to be? And then they submit that to the state bar for approval to run their program. So that's why I was asking, like, I don't know the answer to this. Like, is there anything we can do with the approval process or the minimum guidelines to like cement in the fact that they should be providing reasonable accommodations, even if they're only doing Zoom only arbitrations?
Hmm.
Yeah, Rachel, do you have a thought about that?
I also did not realize that the state of the law had changed so much in terms of that initial question, that I feel like that really kind of complicates things. If we're looking at rule changes to, COBRAC has really purview over legal ethics. And I think that any potential rule changes related to this sound like it is probably outside of our purview. So I guess the question at this point is, is exactly what you were saying, Novella. How do we move forward given the current state of affairs?
Allison.
So, first of all, when I read through your analysis, I also too was like, oh, it's not a public place because it's all online. Seems crazy to me. But with the push for the bar to have bar associations and attorneys and push programs for what's the word I'm looking for? DI, right? Like to inclusion. Here, people literally aren't being able to be included because they can't see or they can't hear. Could we put it maybe somewhere under those obligations that then the bar associations, even though it's not a public accommodation under ADA, you would still have to do it under the ideas of DI. I'm sorry, I'm not articulating well.
Allison, are you thinking about the I want to say it's like in the 8 something rule?
The discrimination rule 8.4.
A little in the 8.4 and also in some of the just language that has been coming out lately about the bar asking for organizations to certify themselves and things like that. But yes, also in 8.4.
So I think I guess one issue, if we were trying to squeeze it in 8.4, is some of the arbitrators aren't attorneys. So even if we squeezed it in 8.4, we couldn't apply it to the non-attorney arbitrators.
I gotta pull up 8.4. I'm a little.
Yeah, I just put in I think we're talking about 8.4.1, which says in representing a client or in terminating or refusing to accept. So it does not.
It's already outside.
Yeah, there's another one that's in relation to the law firm's operations, but I don't think it would apply here. I mean, there's obviously conduct prejudicial and all that stuff, but
yeah.
Okay, maybe we should just go back and all consider this and with staff think about, because it was a surprise to learn that things have deteriorated. I mean, I think the idea was originally that it was just going to be relatively straightforward to update. That certainly isn't the case.
That makes sense. And I can check with Arbitrator Stone and the others that requested this and kind of maybe check in and give him an update and see if there's any ideas there.
Yeah, I think that would be a good idea. It might help to learn what in practice they would find to be helpful or what object they had in mind. Okay. Let's do that, and then we'll come back on this issue in the next one. Does that sound okay, Novella?
Yeah, thanks.
Okay. Anything else on this one? It's 11:51. Before we get into the next item, which is AI, and Nima, let us take lunch between now and 12 and 1:50. Sorry, 12:51. Sound good?
What time
Yeah.
are we coming?
12:51.
12:51.
Okay,
Thanks, everyone.
thank you.
Thank you.
We're recording.
All right, thanks everyone, and welcome back. We're just going to keep moving through our agenda items, which brings us to 4.8, discussion of artificial intelligence. And for that, we'll go to Nima.
Thanks, Dan. Just to give a more general update, we have had two initial calls, one with our internal team and one with our outside experts on the AI work stream. We have two outside experts, Professor Dan Rodriguez from the former dean at Northwestern Law, current professor there, does a lot in the space. And then we have Daza Greenwood, who's MIT professor and is a very sort of well-known, published individual in the AI space. We have kind of like set out our initial kind of work stream and where we're focused on. And I think our next meeting is going to be on December 9th. It's next week sometime. But that meeting will be sort of, I think, the first meeting where we're actually going to be digging into the guidance that we issued in 2023 and seeing where, as applicable, we can update the guidelines and whether or not comments to the rules are appropriate in this case. So work stream's moving on. Everyone on the team has been a extreme help and great value add. So looking forward to moving that forward. I don't know if anybody has anything else to add from the committee.
I was going to ask whether any other states have started to do this. I got some materials from Illinois, where I'm also admitted, and they had a really good AI guide. But I wasn't aware of whether any other states have actually started working in these concepts to the comments.
I don't, from what I can tell, not to the comments yet, but there's certainly been a few. I think maybe I'm trying to remember if Arizona. I know Arizona did something recently. I don't know if it was a change to the comments, but that's definitely what we're compiling, and we'll consider as we move this forward.
Okay, that's great. So do you have a sense from the folks that you've talked to, these are obviously experts, that it's moving at a pace where we could make an actual significant comment that wouldn't be out of date in 3 weeks?
Good. That's a good question. Yeah, no, I think that what we're really focused on, and I think it's consistent with the Supreme Court's letter, is the idea of the implementation of agentic AI, which is much broader in scope than what we dealt with the first time around. And I think that's going to be like, if you just kind of take agentic AI for what it is, like autonomous systems that you kind of set up and wind the gizmo and let it go. That's pretty much going to, in my view, going to cover future iterations of technology that sort of come under that umbrella. So I think that we want to be very mindful and careful about the guidance that we put out, because obviously this is something that every law firm is wrestling with and every lawyer is wrestling with. And there's a lot of activity, both from courts in terms of issuing sanctions. There's been recent California Supreme Court opinions issuing sanctions. And, we want to make sure that the guidance that we're giving is mindful of all of that and not, as you alluded, potentially outdated the moment it comes out. So that's the goal and objective. And I think that the expertise, certainly not my expertise, but the expertise of the folks on the committee are going to be useful to that end. We also think that it's probably going to be a good idea to do something like we did in 2023, which was have a public style hearing where we could invite folks from the profession, from the tech community and so forth, to provide their thoughts on how this should look and what considerations the committee should take as we engage in this important work.
That sounds great. All right, thanks, Nima. Anybody have any other questions or comments? They're in progress, it sounds like. Okay, thanks. You can have agentic AI write your comments, maybe. I'll try that. Let's go to item 4.9, which is a civility discussion, and Eleanor.
So this kicked off, I guess it was about a month ago. We had a meeting, Rachel Catherine and I had a meeting with the California Civility Task Force, also known as CCTF, which you'll see that acronym a lot. It's a joint, for those who don't have the background, it's a joint project between the California Lawyers Association and the California Judges Association. They developed the Civility Task Force, created a report, made recommendations to the Board of Trustees, and otherwise submitted a petition to the Supreme Court, along with some recommendations of the bar that were in the petition. And the court rejected them. I'm abbreviating a bit here, just for the purpose of background, but what the court said, the Supreme Court said in rejecting them, was that it encourages the bar to explore the possibility of codifying existing case law to reduce the request for attorney's fees based on incivility, and to study the effect of the new continuing education requirements. I think that latter request is not in our scope. Rachel, I don't know if you have a different view on that. I know you were going to kind of look into it, but I think that one's going to fall outside of our scope to assist on, unless we hear differently. But so where we are is in responding to that invitation to look at codifying existing case law, and then also evaluating what our role is going to be in working with the task force going forward. They are in I would call it a regrouping phase, where they're looking at their strategy and trying to figure out if they're going to propose additional rule changes or different rule changes and try to address the court's concerns, a lot of which constitutional. And they're looking at that effort as being something that's likely an 18 to 24 month effort, which makes sense to me. And I'm not sure yet how. I think the working group will have to evaluate whether and how this committee should be involved in working with them on that. I certainly think there's an opportunity for us to work together with proposed rule changes, et cetera, if they bring those forward, or if we decide we want to do that. But in terms of laying out a strategy, like a legal strategy to build case law to support where they're going, I think that's sort of outside of our scope. So there's some discussion to be had there about whether and how to engage. But the first order would be to establish a working group. I think, Adam, you previously volunteered, and I'd like to encourage newer members to volunteer given the time horizon on this one. So if we could get like 2 additional newer members who are going to be around for at least 24 months, I think that would be the right composition. I see Erin raising her hand.
I'd
That
be
was
interested to help Eleanor.
fantastic.
Raquel has her hand up. I don't know if it's a comment or a volunteering.
Well, as a question, because at the last meeting, we took volunteers for the working group already. So I was not clear as to whether or not, Eleanor, you're reporting on a meeting that's happened since last month or reporting on something that happened before, and then you just asked for volunteers. But we did ask for them last meeting, and I was one who volunteered. I don't remember who else
I
volunteered.
didn't realize you were here, Raquel. I didn't realize you showed up. Adam also volunteered.
Yes.
And
Okay,
encouraged
yes,
that we
okay.
have newer members. I don't know how much of the preamble there you caught, but I was also encouraging we have some newer members volunteer so that there's longevity and continuity.
So has there been a meeting since the last
There has not been a
COPRAC meeting?
There's not been a working group meeting. I was invited to a different meeting to kind of get the background and figure out where things are, but no, we have not had a meeting. I think that will be a next step. We'll have to assign roles, get together, have a meeting. I can give a more detailed report on the meeting that I attended, and then we can talk about the work of the working group. I think one thing that's pretty clear we could probably be helpful with, and Rachel, I think, mentioned it earlier, is there is a toolkit, civility toolkit, that I think the bar is ready to roll out, and training requirements that they might need some assistance finalizing or reviewing, which I think the working group can do that as a first order of action because it'll be quick and impactful. But with respect to whether or not we're going to do any ethics opinions or work with the task force on legal strategy, I think that's a bigger discussion.
Okay, so it sounds like, based on what you've said, I know what I volunteered, I thought it was something different. I thought we were taking COPRAC members to be a part of a working group that already existed on civility outside of COPRAC. But it sounds like you're looking for now something that's just internal to COPRAC.
It is internal to COPRAC and will work with groups outside of COPRAC.
The group being the Civility Task Force, which is like 10 or 12 people, right?
That's right.
Right. So that's what I thought I was volunteering for. So at this point, I'll stay a volunteer. I'll meet and hear what the work group is, and then I'll decide whether I'll continue with volunteering. So I just be transparent about that because I thought it was something broader.
I think to the extent you're not interested, Raquel, I do think having longer term members, if I'm not mistaken, you're about a year away, right? I think having people who will be here for the full 2-year effort working with the task force would be valuable. So if no one else wants to do it, your input is obviously valuable. I think you are involved. I'm not trying,
Yeah, I'm not stepping down just yet, Eleanor. So, but I just want to be transparent because it sounds like what we volunteered for last month, it has now been reframed based on the meetings you've had, which is fair. I mean, I don't have a problem with that. It's just, I'm just saying to you, oh, it's different.
The meetings aren't actually, they haven't changed anything in terms of the structure of our group, but I appreciate that maybe that wasn't clear. So
okay, thanks. So at this point, I'll stay. I mean, certainly other people can join as well, but at this point, yeah, I'm not really relinquishing my position on it. Thanks.
Okay.
So Eleanor, from what you heard at the task force, I thought we discussed last time that the sort of directive from the Supreme Court was more about judicial remedies and making those things more enforceable rather than rules-based changes, which they didn't love. Is that right?
They didn't, and they're looking at codifying law, but the task force is interested in trying to take another run at it.
Yeah, okay.
How they go about that, I think will probably determine whether and how we should be involved. And that's not clear yet. That's why I think this is going to have a long runway. Seemed like, we could probably expect to hear back from them in several months about what their next steps are. And we can certainly reach out in the interim. But
yeah, it is interesting because everybody sort of talks about wanting to have civility norms, but nobody really wants to have rules that require people to be civil to each other, which we talked about in this committee before, will actually give lawyers the ability to tell their clients, I can't do this thing the way you want me to do it, for example.
Right. I think, I mean, it's challenging, and the court has indicated the ruling, I think, makes clear how challenging it is going to be. We did have some discussions about empowering, once the training is available, the judges will be empowered to order training for folks as a kind of a consequence of incivility. And other things that judges can do to discourage that type of conduct in the courtroom. But
yeah, it's not even so much in a courtroom,
Well, that's fair. No, you're absolutely right. Yeah.
But yeah. Okay. Well, that's also TBD. It sounds like there's a long tail on that one.
There is.
All
Can
right.
I provide a little bit more context on the civility issues? I think it's pretty clear from the Supreme Court order that they want COPRAC to look at least codifying some of that case law related to reducing attorneys' fees due to incivility. There are at least 2 published cases in California on that issue that staff provided to the working group. So I think that can probably be one of the focuses while we are waiting for some additional information and feedback from the task force. We reconvened this working group, the civility working group, recreated it because of the Supreme Court's order on the civility issues and their specific asks of us. And Eleanor, I agree. I think that second part of the order is probably more something for the state bar than it is for COPRAC in terms of tracking the impact of this new civility CLE requirement. But at the very least, I think that we can get some movement and traction on adding comments to the rules. And I think that it seems to be part of the feedback that we've been getting overall from the Supreme Court. I think that they are willing to adopt rules. They just want it, especially when it comes to these issues where there are constitutional issues at play. I think they want more of the case law and the backing to support it, which is why I am hopeful for 8.2 and 8.4, because that's really the route that COPRAC took with adding to those comments. So I'm really hoping that we will get a positive result from the Supreme Court on those. And the CCTF specifically asked to coordinate with COPRAC this time around. I wasn't here the first time around, but from what I looked at, it looked like CCTF kind of made their recommendations and then COPRAC responded to that. And the board responded to that. Whereas this time, I think that the California Civility Task Force would like to work jointly with COPRAC from the beginning, rather than issuing a report that then we and the board respond to. It seemed like this time around, they really wanted to kind of work collectively together in moving civility forward. So hopefully that provides some additional context.
Thank you for that.
Emil.
I was going to say, one of the parts of the civility was the change to the oath, which, as far as I recall, only applies to newer lawyers. So maybe there's something that can be analyzed to apply that to have like all even, admitted lawyers that have never subscribed to that new oath take that over. Because I also find some similarities between the AI issue and the civility issue. Civility issue, obviously, sometimes lawyers, we think that we have to be a certain way to impress our clients or to do our job effectively, like zealous advocacy. But the same issue applies. We see lawyers getting cited in the Court of Appeals or lower level courts for being in civil. And we also see lawyers getting in trouble for using AI, even though most of us on this call, if not all, probably know how we should and shouldn't be acting, whether with AI or civility. So I think there is a disconnect, but I'm not sure if a rule is going to solve that or if there's another way to do it. I don't have a right answer, but I just want us to think about it from that lens.
I think that, and Rachel, correct me if I'm wrong, but I think the civility oath is going to be applied to all starting next year. Yes. I think that was addressed, but I like your other comments, definitely.
That's the one piece of the proposal that the Supreme Court did amend and adopt. So starting with the license renewal cycle in 2026, we will all be taking that oath either for the first time and also on a yearly basis reaffirming it.
Kathy, was that your comment?
Yeah, I just wanted to provide a little bit more context about what the Supreme Court's order was and wasn't. But yeah, that's specifically it, that everybody's going to be required to take the oath on an annual basis beginning in the next reporting cycle. And while COPRAC is going to have a working group that's kind of working on some of the issues, it's a little bit twofold because they will be working with external stakeholders as this is a kind of a high profile issue. And the judges are very interested in finding ways to order people who are in civil to do something about it, short of sanctions or short of reporting to the state bar. And so those are all things that we're going to be working on in the civility toolkit. And we're going to be creating an e-learning course next year. And we'll also be asking for COPREC's input on that, excuse me.
Okay, that's great to know.
Where are we with respect to being able to provide input on the toolkit now? Are there any items that are where you're seeking input where we could be helpful as a working group?
Well, so what we're doing is we're finalizing the first draft of it. And then what we'll do is we'll put it out to all stakeholders basically and ask for comments in a set period of time. And then once we get all those comments back, we will consolidate them and update the toolkit as necessary. And then we will take it probably back to the COPREC working group just to make sure everything seems consistent. And then that will need board approval. And so we are anticipating hopefully taking it to the board in the first quarter of next year, but it might be quarter two actually based off of just timing and stuff.
Okay.
Novella.
Yeah, I was just curious about if there's any additional context on why the courts want it to be a high priority issue, because I think what Dan said, like about incivility being worse outside of the courtroom. So I was just curious if there were like specific examples that were informing why the court also agreed that this was an important issue. I don't know if there's specific examples, but they did put a lot of work into at the initial level with this civility task force, that was made up of the judges and of lawyers. And it was really an effort that was being pushed by the judges. Justice Curry was particularly invested in this. And so I think similar to the state bar, they were quite disappointed in the Supreme Court's decision regarding the additional rules that we had suggested. And they want to keep this issue on the forefront. I think one of the additional issues is just kind of the attacks on the judiciary and the kind of just the high profile nature of incivility in society at large. I think those kind of were just the things that are contributing to it. But I think it's just that they always had this interest, and since we weren't successful the first time, well, we weren't completely successful, we were partially successful. They would just want to continue this effort, and they think that it's worth really raising the profile of and keeping it in the forefront of the profession's mind.
Yeah, I agree with everything you said there. I would just also note that on the call, a number of the judges expressed that they felt like civility, like it was just decorum was deteriorating in the courtroom as well. So you can only imagine what's happening outside the courtroom. But they definitely mentioned that they are subject to a lot of hostility and improper conduct in the courtroom as well.
Raquel.
So I think I heard there was a hesitancy to just sanction attorneys in the courtroom. They'd like to try to have some mitigative behavior short of sanction. And I'm just wondering, what is the hesitancy? I mean, it seems like you're going to get people's attention if you start sanctioning them at a high. One, it's the environment. I mean, if you have a president who behaves like he does, it's kind of hard to expect people to behave sensibly. But my question really is, what's the hesitancy to just being very, use the full power of their gavel, if you will, with just sanctioning people.
Yeah, I think that's a great, I think that you raise a great point, but their concern is more around getting through their back cases, right? So they don't necessarily want to drag things on or make things more incivil by ordering sanction orders. And they really just want to stay focused on the case and as opposed to the behavior of the people that appear in front of them. That's kind of what I can get from what the conversations, but I'm not a judicial officer and I don't speak for them. But that's kind of the tone that I was getting, or the kind of the feeling that I've got from them throughout the time that we've been working on civility. And so, yeah, so it's kind of just that they want to stay as much above the fray as possible.
I mean, it depends on the court, but there certainly is a sense that it's a sideshow, and it can be a huge distraction in a case if the court is taking on these things. And then above a certain level, it has to be reported to the bar, and it gets to be its own problem, and it's a sideshow. That's one possible explanation for it. Has any other state, I'm not really aware that this has happened. I know there's some other states that have commissions for civility and they do publications and materials, but I don't think any other state has actually codified civility guidelines in the rules.
Not as of, I think it was either last summer or the summer prior, when that was the last time that the Civility Task Force looked at that issue.
Yeah. And very few even courts have standing orders that really enforce civility directly. I know LA County Superior Court does, or did. Used to cite to that a lot. Okay. And Eleanor, anything else? We'll wait to hear from the working group on the things that Rachel mentioned, specifically related to what our side can do, even independent of the task force.
Yeah, I'll get the roles assigned and we'll have a meeting to talk about those, how we can support the training as well as the codification request while we wait to hear back from the task force.
And there was recently an article that they asked for the state bar's input on. And so I'm going to ask Rachel to send that around, but it does say that 5 states, Florida, Michigan, South Carolina, New Jersey, and Arizona, explicitly allow for lawyers to be disciplined for uncivil conduct. But I'm not sure if that's based off the rules of professional conduct, or if that's based off of, standing orders with the different various courts. But we'll forward that around too. And so you could take a look at that as well.
I mean, even standing orders are something, but they're few and far between in my experience.
Yeah, I would agree.
Okay. Any other questions on this issue? This is one of our priorities along with AI because it was a request from the Supreme Court. So it will be a focus of what we're doing. All right, let's move on to the 2025 work plan and what I think is items on the work plan that we haven't talked about today. Is that correct, Rachel?
Yes, and I will get that.
Are there any such items?
I was able to go through during lunch and I think update most of it. So I think we're in pretty good shape.
Okay.
Yes, we discussed that. I think it was just a handful that we didn't talk about today.
While Rachel is scrolling through, I think we this is part of our continuing effort to make the COPRAC year sort of a defined work schedule so that we have projects that start and proceed and complete within one committee roster. And it's much easier for things to progress along those lines. So bringing it back to the working plan, the work plan is really about making sure that that everything's moving forward, not backward. That's our policy.
So we just need an update on crypto. I guess that was Eleanor. Did you want it on the January agenda?
That was we removed that from this agenda. It should be on the January agenda.
Okay. I think that was it. I think we've discussed everything else on here. Yep.
Okay, we will come back to this in each meeting and just make sure that we are keeping in mind the idea that we want to get some stuff rolling. And it does sound like everybody has pretty good processes in place. There's been a lot of working group activity, I can tell you this much. And thank you, everybody, for that. All right, let's go to the next one, which is the 2026 Ethics Symposium. And we came up with some potential topics in October. And let me start by just connecting with Kathy on that and seeing what precisely we want to do next.
Yeah, so included in your materials, I have kind of outlined some course descriptions for the committee's consideration. And then I've also included some best practices for developing high quality panels. And so what we really want to do is ensure that, consistent with the other ethics symposium, that they really support our educational mission. And we want to ensure that they are of good quality so that we can put them up on our e-learning website and continue to have those as resources for people who are seeking ethics credit. So what I was thinking of today is I would kind of just walk through those documents quickly and then talk about the course descriptions and then get the feedback from the committee, and then we will take it from there. I also want to note that, we are, OPC staff is willing to kind of help walk through the panels and usher the panels through to symposium date. And so that's whether you need us to help schedule meetings, collect materials, refine outlines. We are more than willing to do those things.
That sounds great. Thank you.
Okay, so in your documents, you'll see that we really want to provide consistent quality, strong learning objectives, and sessions that really move beyond theory to actionable goals. And so the best practices documents really gives us a shared framework for building panels that reflect that. And so I'll just talk about those really quickly. And I think that this committee has done a really good job at kind of incorporating these, but it's always good just to level set and put these at the front of your mind while we're developing new education. So we're going to want to identify the primary audience and the ethical problem that's being addressed. And we want to really have learning objectives that really drive all the decisions in terms of the content and the panelist selection. We want to ensure that speakers have a distinct perspective and avoid, of course, people repeating the same message or viewpoint. We do want to kind of have a strong theme or through line that the moderate really introduces at the outset and follows it through. And we want to make sure that we do include some engagement in terms of adult learning theory. People really can only focus for about 8 to 10 minutes. So every 8 to 10 minutes, you should think about either having like a reflection question, a poll, or a hypothetical, or even just changing what you're talking about, because that's about the time length when people start to zone out.
You have 4 more minutes until we stop paying attention.
I'm not going to need it. In terms of quality assurance, we just want to make sure slides are accessible, that they have, verified citations, practical examples, and that we really want the panels to conclude with clear resources and reminders about how to seek additional guidance. So now I'd like to transition just to the topics in your in the other document. So what we did was we kind of looked at everything and all the thoughts that the committee had last time and tried to form them into specific sessions that can be kind of that this committee can, you can change the details or decide if this is how you want to go or if you want to go in another direction. But it's just something to begin with. And so the first program would be the ethical duties in a rapidly changing legal environment. The second one would be ethics and the modern law office. And in terms of let me go back to the changing legal environment. That one will kind of focus on immigration volatility, shifting policies that are policies that are rapidly shifting, client protection, and that one will really emphasize competence, communication, diligence, and the rule of law. The second panel on ethics and modern law office, that would kind of address AI, remote work, staff supervision, confidentiality risk, and technology competence. In terms of the third program, I did give you two options because I know that I know that there was a great title thrown out at the last time, like Beyond the Billable Hour. But I did want us to think about whether or not, I know the succession planning, we put a lot of work into that opinion. So I just wanted to bring that back to see if we wanted to incorporate that somehow. So you have two options for panel 3. And then just as an optional panel 4, civility, just in line with all the work that the working group is doing. And even if this isn't a symposium topic, I do think that this is a topic we might want to put on next year. Maybe if it's just a statewide CLE, even just with COPRAC members, I think it's something that this group should consider. And so each program does identify the core ethical duties and the problems that attorneys are facing. And we really want to make sure that scenarios and engagement opportunities are really built into it. So at this time, I would really just ask for the committee's feedback on if they like the programs, if they want to refine more, and how we want to move forward.
One quick note on the program 3 options is that the State Bar has prepared and we're sort of reviewing and just sort of editing and but close to being done with that succession planning tools, which I think will be launched. I don't know exactly the timing. Maybe it's January. So that could be a good follow-on to that. Rachel, did you have that sense of timing?
Yeah, I think January, absolutely. They'll be ready to go and we'll be able to put it up on the website. So
this is the number one question that we get in our practice, and we had the succession planning outline, or I mean the opinion, and now these materials, and then so that this either could be complementary or possibly overkill, depending. Aaron.
No, I was going to say, especially with that idea, that the second version of the third panel makes sense because it talks about billing properly, handling funds properly, and keeping your fund your practice going if so succession planning. So it would be more like a survey type of a 1 hour jam packed, but it could introduce all of those different areas, which I think a lot of lawyers get hung up on.
Yeah, that's probably what most people hit a wall with. So we talked about this last time, but then I'll go to Raquel. But it seems like those types of issues probably would be more critical to solos and small firms. What's the audience? Do we understand the audience to be that we're talking to?
I'm not sure if we have those demographics available. Raquel, excuse me, Raquel, I just saw your hand up. Rachel, I think that maybe we can check with Mimi and try to break that down, but I'm not sure if we'll be able to get that information today.
Okay, yeah, no,
But
it's not urgent, but I'm just curious. We can target these at all kinds of different size practices, but Raquel.
Question and comment, maybe. The question is, there has previously been a introductory session, usually the chair and the vice chair, and the sort of current topics. I don't see that in this outline. Is that being thought not to be worthy of the symposium anymore? Question is to you, Dan.
Yeah, I don't know the answer to that. But was the idea that wouldn't be the first session? I just sort of assumed it would be, but doesn't have to be necessarily.
No, I don't. I think that I just provided you different options of other programs that you could include. I think that the current topics is a really relevant one. And if we decide to maybe not do succession planning, or if we think succession planning is overkill, or civility, if we don't want to do civility, those are all things that could also be brought up in an introductory section with current topics. So
that's what I was going to suggest, is that if we get one of the options that we decide not to make a program, it could be would certainly qualify as a current topic that the first session would address, I think.
Yeah, so the topics are you can take them or you could throw them away or you could give me a whole new set of things you want to do and I can come up with other descriptions for other courses. It's by no means meant to limit the group at all.
Okay, thank you. So I'm glad you said that. I feel restricted by what I see, meaning in the past, we've sort of decided these are the topics, and then the groups have taken it and developed a symposium. And I feel like staff is doing it, and it feels a bit restrictive. And two, I would definitely say, Kathy, your strength, which is learning and development, right? So it's done that way, but it feels too tight, not necessarily exciting for people to come on some of the topics. For example, the one that's on technology, I think, I don't think is that exciting, right? I mean, so so I'm glad you said, hey, we don't have to take it, because I felt like it was so perfect that we had to take it. And so I mean, like, I'm not going to just start saying a bunch of stuff, but I just say that as a context, right? Because the rest of the committee may say, hey, we like it and we want to move forward. But that's my feeling. I certainly do have some other topics and ways. I do definitely think the first current events, I don't remember what it's called, but that one always seems to get a lot of positive response. So I definitely think we should have that. I think immigration could be, one of the topics is covered. It seems like we don't ever go too deep on any of the things, but it's a breadth of things that you wouldn't spend an hour on, but you could spend a minute on, or 5 minutes or so. So I would advocate at least for continuing with that. And I'm over.
Okay, thanks, Raquel. And thanks, Kathy, for doing this, because part of the rationale, which we talked about in October, was we at least need a starting point from which these things can be developed. And this is a very good one. So, Emil.
So I think this is great. I agree that certain things can be, like, obviously titles can be changed to make them more interesting. But as Dan just mentioned, I think it's a great starting point. I would just comment that I definitely think we want a civility program as part of hopefully something that comes out of the group next year. But also people need civility credit. And then maybe we should try to focus on, again, an AI program that you have listed here that would qualify for the technology credit. And if I know this is an ethics symposium, but if we could try to hit all the specialty credits, like if we could get something in elimination of bias or something, I think that would be very, very helpful and attract more people. I do recall somebody saying that this past year there was an issue with how many registrants we could have and if there was something to do to expand those. And then finally, for that introductory one, is there a thought that we might want to have a year in review to say, here's all the things we did in the last 12 months? Like just so everyone knows that if you don't look at our opinions, here's like the 5 opinions that we published. And obviously the rules that came out, I think that might be just helpful as a reminder for people.
Okay, thanks.
Our opinion number is not 5.
What is it actually?
We did not get any opinions out in 2025.
Okay, well, we still have time. Actually, we don't. Okay, fair enough.
We did a lot of other good things.
Yeah, the rule work really took precedent, I think, last year.
And 3 rules. So we did a lot of rules this year.
Let's talk a little bit about the process, because I think that'll help just sort of guide us going forward. So this is an April program, and we want to finalize this by January, February. Is that the idea, Kathy?
Yes, I would say February probably. I mean, of course, it's really getting the titles and descriptions so that we can start advertising and then fine tuning everything else and kind of filling in the details. The Zoom registration, I think we are able to have up to 1,300. I think the symposium attendance has been around 500 or 600, but I can check because it might be higher. Typically we get more registrants than those that attend, but because they want the, the recordings and stuff. If we make those available and they never know, so they sign up. In terms, we have traditionally always done 4 hours of ethics in the symposium. But if you were interested in doing other programming throughout the year, I mean, we would be more than happy to assist with that. Technology. We have toolkits on AI and technology. We're finalizing our civility toolkit. So I think there are, and we have a EOB, we have a competency course that we can easily give specialty credits for as well.
Aaron.
I was going to say for the LA County Bar's Ethics Committee, I do the Ethics Symposium, usually setting it up. And we have, I think, March 10th and 11th. We already have all of our topics set, and we're just getting ready to finalize the descriptions like Kathy is doing now, so we can get it on the calendar and start marketing, because you need, 2 months in order to really penetrate the community that may want to be interested. So I do think the sooner we nail down the topics, and then you need the descriptions. And my experience, I don't know about Kathy's, is that you need bios and the headshots, so you can do like a little blurb on the speakers in the marketing. Is that what you also do?
I don't know if we've been that extensive, but I know that there has been a push to kind of raise the profile of our marketing. And so I think that that's a great idea. I think that those are all great ideas, and that I think they should be incorporated. But of course, I leave it to the committee. I do not want to be too strict or rigid. I'm just trying to provide a support and, a starting place.
And I'm happy to work with that, because I've like the last 4 or 5 years I've done the PREC Ethics Symposium. So having a theme is a good idea, but sometimes it's really, I'll just tell you my experience. It's just getting people to like fill in the 4 slots is sometimes kind of hard. So to do a year in review, highlight of the last year, of which there always is stuff. Then I think this year we're doing trust accounting and the audits, because that's super big. Lots of interest there, as there should be. And then advertising is big right now with the SB 37, huge. But I do think, we're not doing civility. Oh, actually, we are. Does civility still matter after the rejection of the Supreme Court by the order? Yeah, that is one of ours as well, just to let you know.
We can't wait to hear the answer to that.
It does. It matters still, because you know what? It's cheaper for your client if you're nice.
I agree. Not everybody cares about that, but yes. Well, let me just propose in terms of a structure for what we could do is actually assign people to these slots. I think that's what we did last year. And then have the groups kind of refine and define what they want the thing to be. It might also be driven by who they can get or want to get to do it. Is that how it happened last year? People were assigned to certain types of topics, and then they kind of worked it out so that people could come back to us in January when we basically need to be ready to roll by the end of January, right? And they've got a pretty well-defined title, concept, some speakers, and those all go hand in hand. Does that process seem like it would make sense?
In the past, I would just say people volunteered for the topics they wanted, and COPREC said yay, no, up or down, whatever. And then we just proceeded. We didn't come back and say, these are the speakers, this is the specificity, because between now and January, we're not going to have our speakers. And so there was a level of trust to say, we're going to get competent speakers that are going to that are going to fit the bill of what we're looking for. So that's how it's been done a couple of years. I've been on COPREC and have been a facilitator. There was not a lot of massaging by the committee of the topics. Once we agreed these are the topics, and these are the people who are going to take the lead on each panel. So that's in the past. I would say, and I'll just do it because I think you're going to move to assigning, Dan. I would recommend, based on people's feedback over the last few years about the AI panel, I would suggest we consider, people have said like you're way above our head in terms of we don't even know how to use some of these products and what's the use case and what's the practice. Trying to figure out some kind of workshop in an hour where you, and obviously we're going to have it around ethics and the ethical consideration. This is the use case. Here's one or two products, and people can interactively engage with those products and learn, because it seems like that has consistently been the feedback, is that this is interesting, but this symposium is ahead of our use. Like we don't actually, like we know it's a problem, but with ethics, but we don't even know where we would start with these tools. So I think people would appreciate it, and I think it would go to Kathy's point about people's engagement level and be a little bit more active. So that would be something I've been thinking about based on just looking on the feedback.
That's been my experience. Which is that you really can't underestimate how much at the starting point lawyers are with AI. Novella.
Yeah, I agree with Raquel. I went to a 1 hour lunchtime MCLE that the California Black Lawyers Association did. And it was like essentially a demo. I want to say it was of Chat GPT, and an attorney walked through like, this would be a good use of it to start doing this particular task, and like this would be a bad use to it. So I feel like there's like, if it were a demo, I think it could be helpful to know like how to do it, but also like, don't do this, like it'll mess up something, or like then you might end up citing a case that is made up or whatever, but flagging the like pitfalls as well, instead of just only focusing on the best practices.
Yeah, that's where most people are. I think that's a good point. Eleanor.
What came to mind for me when I was listening to Raquel's suggestion was being cautious about like endorsing any types of tools and things. I think that could be not a great idea, but I appreciate where you're coming from. I don't know if we could come up with examples that are sanitized, of how things work. I do think one thing lawyers don't focus on that could be useful is to walk through the common terms of use of these types of services so that they understand the need for proprietary services, or the risks anyway, if they're using publicly available ones.
That's kind of what that Illinois resource that I got, that I referenced, that I think I thought I sent around to the AI folks, but it just sort of was kind of like a glossary of like, what are you even talking about when you say X? Right. And what are the threshold types of things? You can dive more deeply into it, but you can also stay at a sort of a lawyer level where you just know what the parameters of the thing is. That's where most people are at the moment, I think.
That makes sense to me. I did read something recently about a law firm doing an AI training via chat or escape room for their new associates, which sounded fun. I have no idea how they did it, but if anybody's creative, that could be fun.
The entire firm is an escape room. What are they talking about? Allison, go ahead.
I agree with you, Eleanor. That was the first thought that came to my mind, is about endorsing one AI, technology over another. At the same time, organizations like Clio just did an AI tutorial yesterday. They had like a 3-hour one. So I think we could get or reach out to some of those bigger companies and see if they would give us 1 or 2 people to run over some of their basic programs that are out there.
And I'll just note that was some of the feedback that we received from this year's symposium with the AI panel we did. We did get several people in the chat and in the feedback forums indicating that they felt like it was a sales pitch. And that I feel like was very mild in terms of what was presented there. So I think, Eleanor, your comments about not wanting it to come off too salesy or feel like we're endorsing one particular product, I think that is well taken, especially given some of the feedback that we already received from what I would consider not at all endorsement of a product.
Yeah, it wasn't, definitely was not an endorsement, but it was a Harvey person. And we did give a disclaimer. I mean, I think it's hard to learn about a product without knowing using a product. I mean, so I wouldn't not do it because people think it's a sales pitch. It's to inform you, since you say you're not informed. So I wouldn't worry about that if you have a membership that says, I don't know about I don't know how to use the products. I mean, I think, so, but I did see that also, Rachel. And I think, it was Harvey, and it was said, even I was the one that said it. This is not an endorsement of Harvey. And it also said it in the resource material that the bar is not endorsing Harvey in any way. So I mean, I hear them.
Okay, I think it might be the right approach to go through and actually assign personnel or have volunteers, and we'll attach personnel, I should say. So the first current developments would be, by tradition, me and Eleanor and Cassidy, three of us. So we can connect the three of us to talk about workshopping some of the ideas. I know last year's was very specific based on what was going on, and maybe it'll be similar to that. We might propose something topical, or it might be more of a review as it has been in the past. But the three of us can start with that. So let's go to the second one. And when I say sort of attaching personnel, what I mean is if you're interested in the vague concept here, the task for you will be to work with Kathy and other staff to refine this given the goals, the educational goals that she's outlined. So program 2 would include AI, remote work, technology competence, and supervision just at this moment, but could go in other directions if the people who are interested in those topics refine it. Who would like to jump on that?
Not everybody at once. Not everybody at once.
I would just say this. I'm really interested in the beyond the billable hour. I mean, that was my little topic. But I do, I mean, having jumped onto the AI task force, and I'm doing a program on AI in the beginning of the year, and it's more of like logistics, like not just the ethics, but like, how does this actually help you, and how could it really, really hurt you? I'd be interested in that as well. So I volunteer for more things than I should. I default to yet, which has got to stop.
No, it has to keep going.
So I'm saying if I'm needed here, but I really think I'd rather be on number 3, the second number 3, but wherever you want.
Put you down for number 3, but you can also, can also offer insights to the other ones if you want to as well.
Happy to, because I'll share my slides for whoever's doing number 2.
Bingo.
I did 2 last year, so you can always do 2.
I will do the AI one. And Novella, would you like to join? You're on mute.
I feel like I don't know that much about AI.
You might be the perfect member then, because this is where most lawyers are.
Yeah, I can be the translator for all of the other ignorant people.
No, it's not ignorance, because people have been correctly very suspicious of adopting some of these things.
Sure.
And we're kind of at the point, or we will be soon, where if you don't get up to speed, you're going to be running into competence issues. Like we have some obligations to know what's going on here. Okay. You just got volunteered, Novella, by Raquel, in case you didn't realize that. Anybody else?
I said if she wants to.
Yeah, that's right.
Okay. I'll jump on as well if
all right, and Allison.
Someone else wants to do it.
All right, let's
okay.
start
Typically,
there for
we've
number 2.
only had 2 people, but we can have 3. But it makes it a little difficult to facilitate, and only with an hour.
If you have enough people, I don't have to.
No, for this purpose, it doesn't necessarily mean that everybody's going to have to participate in presenting. It's more about just refining the stuff, and you can decide how many people are going to present and who else will be joining as well. So that's where we are at this point.
Okay, so okay. All right, thanks.
Does that make sense? because not everybody's going to want to present or need to, but people can still contribute to defining the program. All right, so we have in program 3, we have Aaron, and who else wants to be?
I'll do that. I'll join Aaron.
Emil, okay, thank you. And who else? Anybody?
Who said that? Was that Emil?
Emil.
Yes, email.
For program 3.
Again, for this point, it's really just like a working group to refine the topic. You're not committing to presenting because not everybody will want to or be able to, because we're going to bring obviously other speakers in as well. And that's going to be the focus. So it's just contributing to refining the topic and tightening it up with the goals Kathy outlined and with her help. Okay. Number 3, anybody else want to be on Beyond the Billable Hour? Fee structure. This is kind of also really relevant for AI, of course, because when robots do the work, how are you going to get paid? Okay. Well, those two, I think you guys can take it and run with it. The succession planning one was an alternative, and I think the question with civility would be to what extent. I mean, maybe we would put civility into the first part and then have succession planning be the
I like
fourth.
that. Yeah.
That's for
I don't
sure.
think you can do yeah, I don't think you can do a full panel with civility. I mean, I'm sure you could, but
yeah,
you can definitely cover it as a, quarter topic.
And I think it would include the judicial threat issues. That's obviously related, so that would be a recent development as well.
Didn't we have civility last year? Cassie, weren't you on that panel? Or weren't you the moderator of that panel with 2 judges and you?
Yeah, that was just we did do the judicial threats one. But it didn't really cover civility directly, and certainly not since the Supreme Court ruling. Yeah.
Okay, so we will put civility into the first program with the 3 of us, and then I do think succession planning would be a good program, especially because these tools are going to be coming out before the symposium. So, Carrie, go ahead.
Oh, I'm just volunteering for succession planning.
Okay, great. Thank you. Who wants to join Carrie on that group to figure this topic out and get it sorted out?
I can do that.
Adam, great. Thank you.
And I just really want to stress that if we can adjust the learning objectives, we can adjust everything that was drafted. None of that is set in stone. And so if you come up and you have a completely different description, I can adapt and help you create learning objectives for that as well. So I don't want anybody to feel restricted.
Yeah. So the plan is for these different people now where we're all attached to one of these ideas is to get with your group, refine it, keep Kathy in the loop and get her feedback and expertise and other staff as well. And by the time we reconvene in January, we should have tightly defined, titled topics for these 4 sessions. You don't necessarily have to have your participants by then, because as Raquel said, that happens over time. But if you have an idea of the people, you sometimes that's where you start, and then you craft a program around that. But we'll leave that to you, and we will be following up with you as we get closer to January, just to get a sense of how that progress is going. Okay. Anything else on the symposium? Great. Next item is 414, new ethics opinions, rules, and other requests. This is coming back to the conversation we had in October where everybody said, or some people said, I will look at things and decide if something needs to be done. Here we are. We're going to decide today. And you can see, so one of the threshold issues is, do we, if somebody says, yeah, this is a great thing, I want to get into it, are we going to commit to doing that? Or are we going to say if a spot opens or a space is available in the work plan, we'll slot this in? So I want to just start with that question because we develop these materials, we develop the work plan so that we have a pace and a sort of a set number of things to do that are achievable. We don't really want to just keep adding more to it. But if there's something in here that looks like it deserves a space in the work plan, and there are some opinions that become ethics alerts or are downgraded to non-pursuit, these could be coming in. So the first question is, as we go through this, should these be in the work plan or should we just be waiting if there's space? I think the latter is probably the best approach. Eleanor.
I like your idea of the latter, but I'm wondering, I think we eliminated what we had as a backlog for a while because we kind of voted everything down. So maybe the idea of establishing a backlog where things can come up as spaces available would be a good idea. I was concerned.
You're in favor of a backlog?
I am. I am.
Okay,
I like the idea of having kind of the backlog. Hey, everyone believes we should do this, or at least tentatively agrees we should do it. Let's keep track of it and look at it when we have availability.
Maybe an optimistic way to put it would be a queue that, there's things waiting in queue.
That's a better way to put it. Let's have a queue.
One practical consideration is that these are not just in space. These are actual requests, in many cases, that came from humans. And when we decide not to do it, those humans get notified. And when they get notified 4 years later, they're not that happy about it. So keeping them in a queue indefinitely is I would say we should notify them that we're not pursuing it at this time.
That makes sense.
Because that's a reasonable expectation that people have about timeliness that we should stick with. Okay.
I
Other
suppose we could
thoughts?
say to them, if we think it's a good idea, we could say to them, but may consider it in the future in the notice. So that.
Yeah, people love that.
I know.
I think having a queue can be helpful just because now we have this work plan in place where we didn't before. So it is theoretically easy to track things. We cross something out, we can add something on from this queue. But yes, Dan, I know that we forwarded you, the response from someone who was, rightfully very upset that we denied the request. I think it was 4 or 5 years later. So I think if we are going to have a queue, it needs to be, we will be doing this. We are committing to it as soon as there is an open spot on the work plan.
Yeah, I also think because we're in this sort of season of opinion outlines, it also is likely that some of these opinions will just be downgraded to alerts. That's possible. And it's likely based on the work plan, which means there might be space opening up for some of these things to move into it. But if we create a queue, I think we're going to be, as Rachel's saying, we're going to be committing to analyzing it or not, basically. That's one of the practical effects we have to stick with. All right, well, let's just run through this because it might be that everybody looked at it and said there's nothing here. Look, Raquel, go ahead first.
I guess I would say after hearing everybody speak, I probably am more in favor of the response being immediate, simply saying we will not, I don't know, I'm going to just use the word respond. That's probably not what I'd say, but we would not take this up at this time so that we are not making a commitment externally to something that we don't know, right? So I don't want to make a commitment to do something that we don't know if we're really going to do. Because when the time comes in the queue, something else may have come that supersedes what we thought. New people, a lot of different dynamics. So I'm okay with us keeping a queue internally so we can come back and evaluate. But I think in terms of the communication to the person, what they're interested in knowing is, are you going to take it up now? And the answer is no. Right. Our queue is irrelevant to them, and I think we should separate that communication.
That's a good point. I agree. I think that if we put something in the expected category and we're going to put it in the queue, the response and the immediate response is like, we're not going to do it right now, but we may in the future. but we would send those responses out so that we can just make it clear and we don't have a lingering. Because even if it does come back into the work plan, as you say, Raquel, it's likely to be different as time passes. Okay, well, let's walk through these and see if there's anything here that people felt strongly about, emphasizing strongly, and want to then lobby for the committee to agree to take it up. Rachel, do you want to just go through the list?
Yeah. So first up, we had ABA Model Rule 1.16, Riley presenting.
Hi. So if I recall correctly, this one actually the committee already declined and it just was not updated on the list. And so I had started to look into it. I had created a presentation and then I found out that it had already been rejected.
Okay.
So we don't need to consider it.
Okay. Thank you. If it changes, if there's new ideas that come in, then you can come back to us if something happens you like.
Just the quick and dirty on that is that Rule 116 was updated. The model rule was updated from pressure from Congress to in order to keep oversight out of federal hands. The ABA needed to update that so basically that lawyers could not be complicit in financial crimes. No other jurisdiction has updated the changes to 116, and as far as my research revealed, every state is in a holding pattern on this until there is further pressure to do something about it.
Okay. Yeah, it's interesting if they make a model rule, but nobody cares. If that changes, maybe we will come back to it. All right, so that's resolved. Go ahead, Rachel.
Next request is regarding comment 8 to Rule 4.2, and that was Coleman.
Yeah. I have a PowerPoint. Can I share my screen?
Yes, I will stop sharing.
Okay.
Wow.
I think this puts me in the correct. Okay. So this was a request by an attorney to review a complaint about an alleged violation of Rule 4.28 concerning a direct communication between opposing counsel and the requesting attorney's client. So the requester wanted us to review the State Bar's disclosure decision. So the State Bar closed it as finding no violation. And then they also wanted us to either issue a formal ethics opinion that confirms attorneys may communicate directly with represented parties whenever there is a statute that authorizes the communication, even if the statute does not expressly override Rule 4.2, or to affirm that the rule prohibits direct communications with represented parties unless a statute specifically authorizes the communication. So between both of the requests, I think the thing that the attorney requester is getting at is that based on the closure decision, the requester is inferring that the State Bar thinks there does not need to be an express authorization of violating the no contact rule and wants that to just be said. So that was the request. The relevant rule is the authorized by law exception, which is in 4.2. And then I can also just provide some context on the particular fact pattern of the requester, and then my thoughts on how we should respond to the request. So all of us are familiar with the no contact rule. You're not supposed to communicate with a person represented by counsel without the consent of the other lawyer. And the rationale for the rule is to preserve the attorney-client relationship and the proper functioning of the legal system. And a lot of the case law talks about like not undermining the adversarial system. And that sort of breaks down if one attorney is like sneaking behind the other attorney's back and getting information from their client. And I guess the other thing to keep in mind about the rule, although it's not really presented by the requester's fact pattern, is like it's more complicated when the person represented by an attorney is an entity, just because of all of the different nuances that are spelled out in the subdivisions of the rule. So the exception is not very clear in the rule. So I agree with the requester that, you know, if you just look at the face of the rule, otherwise authorized by law or a court order, what does that mean? It's not clear from that language what counts as authorization. It's not clear from that language if something has to be explicit or specific or something else, which is why we have the comments. So I think they're right on that front. And then the other thing to keep in mind is like all the jurisdictions have this language and then they construe it differently. So the requester is right that the language is vague, but I think it's just like, do we want to clarify it? So we have two versions of like how the comments, or what used to be called the discussion, try to clarify the language. And I color coded it so you can see like how it has changed over time. So the bottom is the old comment or discussion, and then the top is what we currently have. So one key difference is that it used to say authorized by law meant there is an express statutory scheme. And then when that was changed in 2018, express was taken out. Another similarity is just the examples stayed the same. And in looking at the actual statutes, like, you know, I'm assuming that the statutory scheme protecting the right of employees to organize and engage in collective bargaining is the federal NLRA. So then when you look at the statute, there wasn't actually an express authorization in the statute, which is, I think, why it said statutory scheme and why that part stuck. So even if you look at the examples in the comments, none of them really have like statutory language that says like, and that's why it's okay to violate the no contact rule. Like legislatures aren't drafting rules with the like rules of professional conduct in mind as context. So if you're expecting express statutory authorization, you're not going to find it. And then I think also the like statutory scheme language suggested to me that it was based on like the entire statute, that it wasn't meant to like target a particular provision. Although I think you could like guess about like which parts of the statute help to create this exception and which part doesn't. And then the other part that has changed about the comment is it used to focus exclusively on criminal investigative activity, and now it's like broader for federal and civil. So examples from the comments I sort of already went through. There were some citations of the different types of examples. I would say there were, in my research, I also discovered other examples. I don't feel strongly, using Dan's word, that those all need to be included in the comment, but there's a California Court of Appeal decision saying that a provision of the California False Claims Act counts as authorization by law and analyzes that under the rule. Another example, which I think this was the only example that I could find that was actually expressed, was Penal Code section 939. So for criminal grand juries, the grand jury target doesn't get to have their counsel present during their testimony, like when they're being questioned by a prosecutor, and that is expressly written in the statute. But then that Farno case says that, like, even though the statute doesn't expressly say civil grand juries, it applies to that too. So there really isn't a lot of like legs on the idea that it has to be expressed when you look at the case law. And then there were some other examples that I thought were interesting just from like I had never thought about it before. So there were a few law review articles and then some like outside jurisdiction cases that recognize that some of the exceptions are what you would think of as like a ministerial task. So if you think of like personally serving a summons and civil complaint on a person that you know is represented by counsel, I'm assuming, like me, none of you guys think that that's a violation of the no contact rule. So like this, the restatement of lawyers and this law review article and some other sites are like, this is an example of something that is ministerial, that's in a law that assumes that you can communicate directly with the represented party. Like, I don't think anyone would begrudge or prevent someone from personally serving a civil complaint on the defendant just because their counsel said, I don't consent to you communicating with them. So this particular fact pattern, there was the attorney requester represented a medical provider. That was their client. And then it looks like from the complaint or comment letter that opposing counsel represented a client who was like a former patient of that medical provider. So opposing counsel knew the medical provider was represented, and the attorney requester accused the opposing counsel of violating the rule by directly contacting the medical provider for that attorney's client's medical records. And the state bar said, no, it's fine because evidence code section 1158 is an example of it being authorized by law. And I think that's right, especially if you keep in mind like the ministerial examples of communications that don't really endanger the adversarial system. So evidence code 1158, it does expressly, to the extent you want to rely on that, say that the attorney can present a written authorization to the medical provider. It doesn't say like even if the medical provider is represented by counsel, but I think when you look at the statutory scheme, it's pretty clear that this isn't like a going behind the attorney's back and undermining the adversarial system. It's actually meant to further like the patient's right to petition because they need these medical records to decide if they're going to file a lawsuit or if something bad actually happened to them that's illegal. And then I did find like a practice guide that tied that to the like patient's right to petition. So connecting it to the legislature created this in order to like help facilitate that. So I think the closure decision made sense. I guess the other point is the evidence code section has like form language. So it's not like the attorney who's contacting the medical provider is like, and tell me all your admissions. No, they're just asking for a copy of the record, and the subdivision 8 is like, use this language. So similar to how like when you serve a complaint, the summons, it's just like form language, like you use the judicial counsel form. So I don't really see the rationale for the rule being undermined by this example. So I guess overall, I agree that the decision wasn't a violation, but I do agree with the requester that there isn't clarity in the like language of the rule. There could be more clarity in the comments, but I don't feel strongly about parsing out all of the case law in the comment, given how messy the case law is.
That's great. Okay, this is great. I sort of have felt like this is somewhat purposely vague so that the individual facts of the circumstances would then dictate the outcome because, as you say, there are absurd examples of something that technically would violate the rule if you didn't have this exception, including required disclosures when things happen, like layoffs, warned notices, or whatever. And it's completely impossible to figure out or to properly give those notices when the statute says you have to give it to the person, and you're saying, should I send it to their lawyer? Are they really working with them? Who knows? So it struck me that refining it would make it worse, not better. Possibly. So, Novella, we interpret that to mean, with your excellent presentation, no action.
Yes.
Great job.
No action except to tell the requester that we're closing it.
Okay. No action except inaction.
Full consideration, then inaction.
Yeah, well, we certainly have done that. That was great. Thank you, Novella. That's a deep dive. Very good. Okay, Rachel, back to you.
Yes. Okay. Next up is when lawyers make mistakes. Chivers.
Oh, I'm not on mute. Okay. Well, I don't have a PowerPoint. Novella is making us all look bad, but that was great, Novella, and I think that's a good standard to set for the coming year. I don't have a PowerPoint, but what I do think is that we could do an opinion on this. This is basically, when lawyers make mistakes, there is a ABA opinion, opinion 481 that talks about the duties of first how to recognize when a mistake is made, and then the duty of disclosure that comes with that. And I think we've talked about this before. That opinion is a pretty solid opinion about those particular topics. It talks about recognize a mistake, the duty of disclosure, and then whether or not you have a duty to a former client. The one thing that's missing from that opinion, I think that comes up a lot in my practice, is when the mistake, or more specifically, a potential malpractice claim or potential claim by the client against the attorney triggers a conflict, raises a conflict that requires informed consent to continue the representation. And the two issues there are, what does it mean? Well, first, you have to recognize the mistake. That's one thing, and that, that can give rise to a potential claim. But there's the other piece of it is, well, what if there's a dispute over whether or not there was a mistake made? What if it's just the client thinks you screwed up and you don't? And there's language, and there's not a whole lot of case law on this. The Ron Mallon book basically talks about the duty of disclosure. This is a treatise on legal malpractice. Explains that a duty of disclosure arises when the lawyer knows that there is a non-frivolous malpractice claim against him, such that there is a substantial risk that the lawyer's representation of the client would be materially and adversely affected by his own interests in avoiding malpractice liability. So what does non-frivolous mean, and how does that fit into the context of that rises to the level of a conflict that triggers the duty under Rule 1.7b, which is there a material limitation conflict? So I think it's worth an outline of an opinion to discuss whether or not to move forward with an opinion on this particular issue to build on the ABA 481 opinion. So that's my non-PowerPoint short presentation. I open it up to the committee on your opinion on that. Or you want me to just move forward with preparing an outline, I'm happy to do so.
Okay, thanks, Cassidy. Does anybody else have views on this, yay or nay? Rachel, what should we do for this? Do we vote yes, outline it, or vote no, don't pursue it? Or how do we handle this?
Yes, since this is a request for an opinion, then we need an official vote if we are going to move forward and consider it, or if we are denying it. If you want to delay the vote until we get the outline and can review that, that would work.
Okay. Yeah, I think well, I would recommend, and I'm happy to hear other people's opinions, that we get an outline. So it would be another phase where we say, like, we're going to get an outline at the next meeting, and then
Yeah, I can. Yeah, sorry.
and then decide.
Yeah, I mean, I can prepare an outline pretty quickly. And I probably could have had one today. So I guess my question is, do you want to put together a working group or just have me do an outline? Because
I would
I
say
don't think I need it.
you do an
Go
outline.
ahead. Okay. Yeah.
Does everybody agree with that approach? Okay. If you don't have an outline, we're unlikely to proceed.
Okay. I'll take that as my consequence.
Okay.
That's yours, Dan, 1.7. Oh, wait, no, sorry, Carrie.
Okay, Carrie.
Very confusing having so many Irish people on Cobra.
That's right.
Yes. So I too do not have a present PowerPoint. I do have a Word doc though, so we'll go with that. So the highlight here is that in 2018, when we moved from the old rules to the new rules, there was some language that was added to Rule 1.7, which addresses current client conflicts of interest. And why the language was added is a little unclear. It was passed by a narrow vote of 9-8. And it probably was added just so that there could be so that it would mirror the material limitation conflict language that's right above it. But let me show you. I'm going to share my screen so you can see what we're talking about. So what we're talking about, oh no, it turns off my video. Let's see if I can do this without being, this is why I am not on the tech presentation. Okay, so this is Rule 1.7, and so 1.7a talks about, that is a direct conflict. That's where you're going to be adverse to your current client in a matter. Rule 1.b is a material limitation conflict. And that is, you can think about like where you're not adversely direct to a current client, but maybe you are taking some kind of position that would be materially limited by duties that you owe to your other clients or to your own interests. And then there is this other area, which is not a material limitation conflicts, but this basically says, hey, even when there is no risk that your representation is going to be materially limited, we're still going to make you disclose to the parties that you have a relationship, business, financial, professional, or personal, with parties that are involved in the matter. But then we added in this little language here that says, or responsibility to. So that is unique language. That or responsibility to does not appear in the model rule. And then I didn't check all 50 states, but I did kind of poke around for some of the major ones, and I couldn't find any other states that had mirrored the material limitation language in B for responsibility to C, which is the disclosure even when there is no risk of material limitation. And so you might be asking, like, why does that matter? And I think the best way to think about it is through an example. So you're in a law firm, and one of the lawyer's partners previously represented somebody in like a confidential family law matter, like a restraining order that never happened, or maybe a divorce that was contemplated but never filed, something like that. And then now this lawyer wants to represent a corporate client in a completely unrelated case where the former family law client happens to be a witness. So not adverse, but we're just talking about a witness in this like business dispute. Under the way the rule is currently drafted, in order for the lawyer to be able to ethically take on the representation in this corporate dispute, they would need to disclose to all of the parties in the litigation that one of their law partners previously represented the witness in like an unrelated matter. If you accept that the duty of confidentiality is a responsibility to, and that's something that needs to be fleshed out because responsibility to is not defined in the key terms in our rules of professional conduct. So, so you have to first accept that the duty of confidentiality that is owed by my law partner to the family law client constitutes a responsibility to, as contemplated here. But if you do accept that, then under the way the rule is drafted, I cannot take on the corporate client representation without disclosing the prior representation of the family law witness, which then would violate the duty of confidentiality that is owed to that client. So it strict compliance under this rule puts lawyers in a sort of untenable position. And then there doesn't seem to be much of it's not clear why responsibility to why disclosing those relationships would move the needle at all in terms of actual conflicts or risk of material limitations, which is typically what we're thinking about when we're thinking about current client conflicts. So it also was not present in former Rule 310. It was when we transferred from the old rules to the new rules. This language kind of snuck its way into 1.7C, probably mirroring the language in B, but then maybe not really thinking about the practical effects of it. So that is my presentation. If anyone has questions, comments, thoughts. It's not an issue that I had thought about before, but actually now that I'm aware that it's there, it's coming up all the time now, even when I'm like reviewing, duties under conflicting jurisdictions for our attorneys. I'm like, well, if you take this on in Utah, just remember that in California, you have to disclose this responsibility to. So it does actually seem to come up in practice. It's just, it might not be on a lot of people's radars.
Is that because you are interpreting the word responsibility as broader than, say, duty or some other term?
Exactly.
And you interpret it that way?
I mean, without any guidance on what responsibility to means, and I couldn't find any state bar cases because it's a pretty new rule. There's not a lot of interpretation of it, and also it's a sort of California exceptionalism. So we're really limited in our resources as to what responsibility to means. We know what it means with respect to the material limitation. But when it comes to this, it's unclear how we should be interpreting it.
Yeah. What do you propose to do about that?
Well, I love changing rules.
That's your thing.
Yeah, I think that this would be a pretty easy one to digest, analyze, and then decide whether striking the language makes sense or not. So I could put together an outline. If anyone thinks that this is interesting or worth digging into, I could put together an outline about what striking that language would mean, or alternatively clarifying what responsibility to means.
I can say I'd be interested in that because I actually had a trial in state bar court on, them trying to push the envelope on 1.7B. So even with no financial relationship at all, they collapsed all three of the requirements into one by saying, well, it's his sister. So that's enough.
Yeah.
That litigation funding loan company that he referred her to was his sister. And that's enough to create a need for an informed consent. So basically, the state bar's position was, no joke, you can only make a referral to someone you know, family or friend, with informed consent of your client. But then who are you going to refer to? Just the billboard lawyers that you don't know? I mean, this doesn't make a lot of sense. And
People
that's
that you
what
know?
Bob found as well.
Everybody that you refer someone to would be someone that you know, theoretically.
Well, that's the thing. They're saying, well, but unless you have an interest in that referral, there's no reason why you have to get informed consent about, how you know the person. That's why you're making the referral. I mean, there are some limited circumstances, like when you're getting a fee sharing, you have to kind of disclose that. And that's a different rule. But I mean, just in general, that was the OCTC position. So it's something I'm interested in.
Vincent being enforced broadly.
And that's why informed consent is required under B, because you are contemplating some type of potential material limitation to the representation. But C is even more milquetoast than that. It's saying, look, there's no risk of material limitation here, but we're still going to make you disclose it. And then by broadening it to responsibility to, now you have this like very low risk and also very wide net.
The duty of confidentiality, if that were falling into this responsibility language, would make that section really difficult to operate under.
Exactly.
So I do think it would be worth fleshing this out because, like everything else, responsibility to maybe mean something to somebody versus duty, and we can then decide to say it means this. But if it's being interpreted really broadly, clarifying it, I think, would probably be helpful.
Yeah.
Okay. Other thoughts on that question? This is definitely in the weeds of conflict law.
Which is, where I live.
Where you live. That's right.
You're welcome to my home.
Not everybody wants to even drive past that neighborhood, so let's recognize. I would say do maybe an outline. Is that what you propose?
Yeah, so I can do an outline of different options of how we could approach it if we did want to take it up, whether that be adding a comment, striking language, doing an ethics alert. So I can propose that at the next meeting.
I'm in favor of that.
Cool.
Aaron, you too? Anybody else have thoughts? Objections? Hearing none, go for it.
Cool.
Rachel.
Okay, next up is Aaron on ethics alert and pro bono reporting. Did you want me to share your document or did you want to share it?
Oh, no, I'd rather have you share it. Thank you so much. Basically, we did a survey of like other states with reporting, obligations with respect to pro bono and what does it mean to be pro bono. I think that it's kind of clear what does qualify for pro bono based on, toward the end of this. So I don't know what else we need to do. I'm not exactly sure what we were supposed to be doing on this, other than I just was doing a survey of what's coming, so people would be aware.
Specifically, I believe that the requester of this wanted to know if volunteering as a fee arbitration, like arbitrator, if that would count as pro bono work. And just given the fact that the reporting is now going to be mandatory starting with this new fee cycle, there was a suggestion to, I guess, kind of flesh out what is pro bono work, what isn't, if you're doing X, should it be reported?
I don't disagree. I'm just saying I just put together basically where we found basically what requires it. And I think if you look at the very end, I don't think it included, let's see here. It's not directly legal. Well, in a way, providing legal assistance to a governmental or quasi-governmental organization, but that's not for limited need people. I don't know that it falls within, I mean, broadly speaking, although this is not there, and I guess I could do more on this. I mean, when you're serving on as a fee arbitrator, as a non-paid position, either mediating or arbitrating fee arbitrations, you're not providing legal services at all, really. So it's not pro bono legal services. But it is volunteer work, that's for sure. Very thankless volunteer work. So
How about our work on this committee? Would that qualify?
So rewarding though. But I don't think it's pro bono legal services. Right. I mean, it can't really be pro bono legal services because non-lawyers are doing this, right? So that can't possibly be legal services.
Okay, so do you recommend, I mean, one option may be just to sort of wait to see how this develops, or do you recommend actually clarifying this, or is it clear enough?
You know what I would say is that probably, since the purpose of this is to capture those people that are of service to their community beyond just, making a buck, people that do serve as fee arbitrators, people that do serve on committees like this is volunteer community service for sure, right? Just or running a softball team or whatever for the kids, same kind. Very, very much only a small percentage of the population does these kind of things. I do think this idea of capturing these volunteer hours should be expanded to include more than just limited, legal services, to what constitute direct legal services for an underrepresented population. And I'm sure that's what they meant anyways, and it's just imprecise. So maybe that idea is to suggest, expanding the definition of what's pro bono legal services to include what they really want to see, and to encourage, which is work like what we're doing here. People that selflessly agree to be fee arbitrators or whatever. You know what I'm saying? I think so.
Okay. I think the other function of the voluntary reporting, at least in part for the states where I'm admitted where they have this, is to kind of remind you that if you put 0 down, you should do something, right? So that would suggest that the broader definition would really make sense in the context of the intent, which is to remind people that it's an obligation of lawyers to do these things and that it takes many forms. But if you do nothing else, you're not really living up to the professional obligations.
Yeah, and the way that right now it is kind of limited, because even doing free work for people that aren't of limited means wouldn't qualify, at least as far as I can see.
What form? Novella, go ahead.
Yeah, I have a question. I guess on the screen share, when I look at what qualifies under 1 and 2 from the ABA model rules, that seems narrower than Erin's handout on, what page is this? Page 3, where it has like 3 bullet points when it says any of the following. So I feel like the 3rd bullet point is like broader than the ABA one, but I guess I'm not sure how much elaboration people would need to understand what it means. Yeah, like that one, that 3rd bullet point, and then what it means in light of the language before it.
Well, I will just say that this definition comes from the Business and Professions Code versus a rule of professional conduct.
And it may also be, this is related to, there's obviously going to be a more strict requirement when we're talking about doling out IOLTA interest funds. I hope. That should be. But it's not the same. It's not only the same population where, I'm saying that more strict definition of, the kind of nonprofit organizations that would be eligible to collect IOLTA interest funds, ministered by the state bar. It's very different than the interest of encouraging lawyers to consider their, broader duties to the community as a whole to help.
Raquel.
What is the I'm going to say the prompt, but what was Aaron researching? I missed it before we got started. So what is it that this is in response to? On Rachel was showing each item, and then we went to the presenters, because I realized I'm not sure what this is trying to answer. Thank you.
No problem. We are on this one right here. Clarification on what qualifies for pro bono hours for reporting purposes.
Okay. And so, Aaron, you're saying what you did, you think is not broad enough, or so I realize I'm unclear
I think what
on
it is
you're
is
saying.
that, we're trying to say if lawyers are now being told in the state, hey guys, from now on, starting your next reporting period, you're going to need to track your quote pro bono hours. They need to know, what does that mean? Does that mean, which it doesn't, oh, all those hours I had to write off from bad debt? Okay, that definitely doesn't include that. What about all the time I do sitting in fee arbitrations? That was the actual question posed. That should count, I agree, but it doesn't seem to, based on what, the definitions of pro bono legal services, because serving as an arbitrator is not legal services anyways. It isn't. That's why non-lawyers can do that too.
But could the alert have
like this? But
voluntary?
But volunteering on stuff like this should
could the alert have voluntary pro bono reporting that's broader than the Business Professions Code definition? You could, right?
No, but I don't think it's clear.
But I think it could. I mean, it could. You could have an alert that says reporting to the state bar should include the things you do like this.
Yes, all the good stuff you do for the community. I agree. I think that's a very good approach.
Because the Business and Professions Code is used for other purposes.
Mm-hmm. It's necessarily more narrow because we want to be very careful to make sure that these limited funds go to serve the underserved communities. Whereas here we're trying to get a broad swath of lawyers to do more than nothing.
Right.
So,
okay.
Rachel, based on what's being said, does this allow us as COPREC to expand what qualifies?
If it's based under the Business and Professions Code, no, we would. Oh my gosh, I hate this. Sorry.
Okay. So what's our
sorry,
how much flexibility can we have? Where can we expand if we wanted to?
So if it's rules of professional conduct, we would be able to do that. The bar could make recommendations regarding rules to, this changes to the state bar rules. But if it's Business and Professions Code based, it would need to come from the legislature versus us.
I don't think it's Business and Professions Code based because, as Aaron suggested, that's used for a different purpose, right? And so it could be a subset, but it could be, at least from the state bar's perspective, what you have to report could be broader than that. Novella.
Yeah, I guess I feel torn between wanting people to do more than nothing and then stretching it so far that it isn't really tied to enabling the provision of legal services. But if we're not tied to the BMP language, then maybe that doesn't matter.
I think we are tied to it just because I'm looking at the state bar's FAQ regarding the mandatory pro bono reporting, and we are having to do this because of a Business and Professions Code section that was recently enacted, 6073.2. So if it's the BNP code that's requiring us to report and it's the BNP code that is defining pro bono work, I don't think that COPRAC would have the ability to expand that definition at all.
I think that's right. Okay, that's good clarity. Emil.
Oh, I was just going to mention that, yeah, because it's 6073.1, and then this is 6073.2. So it seems to be in the same area, that the requirements and the definitions are right next to each other. So, but I guess outside of that, would COPRAC be the one to say what the state bar is talking about with respect to a reporting form? Like, which is it, the Office of Professional Competence that's going to be pulling this information from licensees, or?
It's going to be under Department of Regulation, which OPC
Okay.
is part
Yeah,
of, but that is not like my role or COPRAC's part of regulation. But yes, it will be regulation that is pulling this.
I see. And then typically, like, if for CTAP, regulation puts out, hey, this is what we want. So wouldn't it also be the same thing? So maybe the suggestion that we would be giving is, hey, we need clarity on what you're going to be asking for. Is it the definition, or do you, maybe you should consider posting something on the website or in the form that says examples of pro bono include such and such?
Yeah, I can take that feedback back to DOR because I know that they are working right now on updating the FAQ and the information for this next renewal cycle. So I can absolutely bring that back to them.
It sounds like that's where the result of this should end up. I tend to agree with Aaron, but if this is it's coming from the statute and going to the statute, then it's up to the state bar to define what they want or need or are required to get. Yes? You feel okay about that, Aaron? Okay. Thank you very much for doing that. Rachel.
Next up was Perlman and People v. Meredith. He indicated that he had to hop off for a last minute court hearing. So maybe we can put that over until January if that works.
Yeah, let's defer that to next month.
And then the last two are both Mad Watkins. First one up is soliciting favorable online reviews from clients.
Okay, Allison.
And I totally dropped the ball. I'm sorry. I don't have anything prepared on that one. I did review the other one, the one about whether or not attorneys can take their work product with them when they leave a firm. That's pretty established. I was a little confused at what the question was referring to because your file goes to the client, right? Goes with the client. So if you leave and your client stays at the old firm, your file has to stay at the old firm with your work product. And then there's been court cases that have said, and there's also a California legal code that the employer actually owns the work product, and it's pretty clearly established. So you can't take it with you unless your client comes with you when you leave.
What was the specific request? Can we just have that?
Yeah. Rachel, can you pull that up?
Can I just ask a question then on that?
Sure.
While you're looking. You said that the employer owns the work product. Is there any determination that trumps the rule that the lawyer owns their own work product? I mean, that's been a pretty...
Yeah. That there's a Tucker v. Ellis, and then there was another one with Nelson v. Tucker that came out in 2020. Those two cases did make it clear that actually it is going back to that California Labor Code, it is the employer who owns the work product. So if you do work product for your firm and you're not like a solo, then it is the firm who ultimately owns it.
And I guess
they have the right then to waive privilege and stuff like that.
I feel like though, well, I don't have the authority on that, but I feel like there's something out there that says that when you leave a firm, like your thought work, your, brain work, you get to take that with you, how do you like...
That's what I thought before I looked at it. If you want, I know there's a fine line. And yeah.
Yeah,
I'll
maybe
be
we'll
glad
take
to
a,
put in a slide.
let's take a closer look at that because I think that would be worth clarifying based on even just this
Sure.
discussion. Because I had a similar sort of approach to Cassidy in mind. Emil.
Yeah.
So this comes up in lateral transitions a lot.
Yeah.
The idea is that the client owns the product that they paid for, right? So if you create a document out of your own, yeah, well, one, you don't like if a client leaves, you don't have to create any documents for them. But if you've created something, you build them for drafts, whatever, you give it to them. But otherwise, you don't necessarily have to give the drafts. If you have a final version that's been filed, you give that to them. But I think what Allison might be talking about is like things like templates. Those are usually covered under the work product for hire doctrine. So it's like an IP issue that you were employed or a partner,
Right.
whatever. So your principal basically owns everything you did unless there's some other agreement. So the idea is if you have a template summary judgment motion that you created while you worked at XYZ law firm, regardless of the clients and the finished work product, you can't take that template with you because that could be a violation of like your confidentiality provisions with your agreement with your firm rather than with a client.
That seems
Yeah, but
really
there's
impractical. But
no,
yeah,
but also, right. I mean, the thing, like, so you have to, when you leave a firm, you literally have to start fresh, because obviously you don't have everything up at, in your head that you've done. And I mean, I know, like, I've looked at this. Well, obviously I don't have the authority, but I think this is a nuanced issue.
and the
But
corporate departure opinion might even address this. Does that come up?
yeah.
I think it might. I would like to look at that.
I
Novella.
don't know between the firm and the lawyer, between the client and the lawyer, I think
There's
that's
also the
pretty
question of
well.
like non-client work, like blog entries or publications, things like that. That could be possibly part of it.
Yeah.
Novella.
Yeah, I was just curious of the sites for the cases Allison said.
Sure. Do you want me to put them in the chat?
Yes.
Sure.
Let's take a closer look at that for next time. I think that would be worth. I mean, even just drawing the distinctions that we talked about here and clarifying that in an alert, I think would be helpful.
And we double checked
Okay.
that there was nothing else related to this inquiry. It was literally just this question here about can a departing attorney take their work product with them? So there was no letter or anything attached.
I think that would be an interesting alert, just drawing the lines of client work, as Emil said, and then even like non-client work, templates, what those types of things would be. Okay.
So is this going to be an outline in January as well?
An outline for an alert, let's say.
Thanks.
Does that seem good, Allison?
Yeah. In January?
Thanks, Allison, for what you put in the chat, which I relate to just overall from employment law, is that an attorney works for a firm. So unless, as Emil said, there's a specific.
That's the labor code that they're talking about in the case. So
yeah, I know. I'm just
because it's not. Yeah.
But
I'm
I'm
going to
just
give you
talking
the other citation.
in general, employment law, typically, as from an HR perspective, unless there is an agreement between the employee and an employer and a specific employee about how that material, just typically it does fall to the ownership of the employer. So maybe there's some nuances. So I was speaking broader than just attorneys, just in the whole field of labor law, employment law. So like I said, there may be some nuances, but traditionally and technically that is from an HR perspective, employment law, that is how that is handled.
One nuance is that an equity partner at a law firm is not an employee. That's one.
Right. So that is right. That would be different. But I don't think the question said partner. It was more employee. Right. So if you introduce partner, that changes what the question was.
Could be an interesting distinction though in an alert, just to sort of draw those lines.
Yeah. Sorry, I have it like in the notepad over here.
Interesting there is relative term, obviously. We're using that term very broadly. Interesting to all of us.
It wasn't what I thought when I looked at it originally. So that's where I came up with that. I did read through the ethics opinions. We did one in the 13-003, and then there was two other ones, but they're all talking about what happens when you leave a firm in terms of the client, not necessarily the work product.
Yeah.
Okay, I think that could be very useful because it may be the case that associates, for example, have a very different
Person.
thing,
Mhm.
others.
Because in some way, what you're talking about is saying that employees have certain intellectual property rights because it's their intellectual property. I mean, I think that is kind of the distinction, but a template could be intellectual property, but it probably is not thought of in that way in a employment situation.
Yeah, and I mean, like what you guys are describing is much more like you work at Lawrence Berkeley Lab and you invent something, the lab owns that
Right.
thing, right? Because they're paying you. But then defining what that means with, say, an associate or a partner when they create a template that they're using in the practice of law, because the departure opinion from COPRAC even does say, the stuff that's in their head, their expertise,
Right.
is theirs.
Right.
Sure. And yeah, and like I can pull up partnership agreements and employment agreements for anyone, and many of them they'll talk about like confidentiality, trade secret, all that. They'll usually define in quotations, this is confidential information, this is owned, so again, anything, and I know I've fought with like clients to say, hey, this is what I think the interpretation is that like it doesn't matter that you created for 100 hours over your career there, you worked for free, non-billable time, creating this template without your firm's permission. I don't think you should take it. That's usually the advice that I would give. And I know it's not fun advice to give, but that's the way I interpret the state of the law right now is that, unless there's an exception, like maybe they're a partner and still you have fiduciary duties to the partnership. But most partnership agreements will talk about that.
So when we're drafting partnership agreements, we frequently put in provisions that suggest that you can take things like that you've done. And
Right.
primarily it's because the people who are going to sign it want that in there.
Right.
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 So, but
But
it
all
would
this
be,
says subject to your agreements.
Mhm.
yeah, that's right. Okay, well, that'd be interesting to come back and talk about that with more detail.
Okay,
There's
so this is
a lot of
January.
issues there in January. Rachel, is that end of list?
That is the end of the list, yes.
Great job, everybody. Thank you for your diligence on that. It was really very good. Moving on, the 2026 work plan. How could it be we're dealing with this? What is happening here? Go ahead. Rachel, do you have a 2026 work plan? We had to vote this out.
I have it. Let me just share my screen, and I will just start by saying that I took a stab at setting some deadlines. I kind of went in and updated that based on our conversations as we talked about everything today. And I did track changes if I did that, so you'll be able to see. But right now, as it stands, we only have deadlines in Q1 and Q4. Any of our Q2 deadlines are dependent upon things being an ethics alert versus an opinion. So as we go through this, I just want to make sure that I highlight that so that we can make sure that we are adding deadlines specifically for Q2 and Q3, because as of right now, there's nothing there.
Okay.
And I think Dan and I both already spoke to this. But I just want to make sure that when we are setting these deadlines, that we are really being realistic about making sure that we think we can accomplish them. Because the last thing that I would want to have happen is that we overextend ourselves and then we have to go to the board and be like, we didn't meet any of these deadlines. I mean, obviously, if there are substantive change needed as a result of comments that we weren't anticipating, there are definitely exceptions. But I just want to make sure that we really think that we will be able to stick to these deadlines, since this one is going to be presented to the board in their February meeting. Okay, so with that, what I did was I just took the 2025 work plan, carried over anything that was not completed. And then I have the notes from the October meeting and the December meeting, just so we can kind of see where we are. And that can help inform our discussion in regards to the deadlines. So 190004 is the first one up. And I know, Emil, you just kind of took in as co-lead for this. So I don't know if we want to keep it in Q1. That would mean we would need to vote it out to the board in the January meeting. Or if we want to push it out to Q2.
I'm happy to try to get this done before the end of the year so that it can be agendized for the January meeting. When you say it has to be voted out by the meeting, meaning at the meeting, right?
Yes. So in order to meet our Q1 deadline, we would need to vote out the final version of the opinion to go to the Board of Trustees in the January meeting.
Perfect.
And I reviewed the public comments that are currently pending. I don't think that there was anything that was going to require substantive changes, but obviously that's something that the working group would need to look at as well. In order to meet that Q1 deadline.
But if we need due dates in Q2,
that's a
wouldn't it
candidate.
make sense to make it Q2 and then we could knock it out of the park in Q1? I don't know if we froze or if I just left everyone speechless.
Both. We're not going to tell you which. Yeah. Well, Emil, do you think that this will be ready to be voted out at the next meeting?
It's been a while since I looked at it. I can try my best, but can you remind me? I can't find on my schedule what day the next meeting is.
It's January 30th, I think.
Okay. Is it?
Yes.
Okay. There I see it. Okay. Yes. I think so. Yes.
Okay.
I'm with Carrie. Let's just say Q2. If we finish it early, we finish it early. But
yeah, I think that's a good idea.
Since we're
changing
somebody's going to be looking over our shoulder.
And that's a good point, Raquel, especially because just the way that the board meetings are scheduled. I mean, it is February 19th, so January 30th is really cutting it close for staff to get everything ready. So I would start prepping things now. The assumption would go forward in January. So basically there's zero cushion if we put Q1 on here. It has to be ready to go in January. We don't have a second meeting that we can use.
I think Q2 makes more sense.
I agree. I violently agree.
For the next one, I would also say Q2 based on the fact that we're going to have public comment, changes to public based on public comments that might require another round of public comments.
Okay, so if we're aiming for Q2, that means that we would need to vote that out to the board by the April 17th COPRAC meeting. Does that timeline work?
If we...
Oh, wait, I lied. April 17th is the symposium, sorry. March 13th is the meeting that we need to vote it out to the board.
Well, I would make it Q3 because probably we'll have a revision. We'll have a revision at the next meeting, and then it'll have to go out for public comment again, most likely. Maybe not.
Okay.
Rachel, is there somewhere, there's not a place where we could have notes particularly, but is there somewhere maybe in the third column where the quarters are where we can have a notation that relates to the things you're saying about the board meeting?
Yeah,
So we'll have it as a reminder. Thanks.
okay, does that note make sense? I'll clean it up later, but I just want to make sure the substance is there.
Yeah.
Okay. This is Q3, so we need to do July. Okay. Next one is flat fees and termination. That one, public comment is still pending, so I'm not sure what that's going to look like. I don't know if we want to move this one to Q2 as well.
Yes.
Yes, I think so.
Public comment is due before the end of the year, is that correct?
Yes, public comment ends on 12/11, so staff should be able to turn that around within a couple days to a week and incorporate that and get it out to the working group.
Thank you.
Conversion clauses and contingency fee agreements. Are we, oh, this one needs to be,
I think we can assume it will be voted out Q1 26.
Say that again?
I said I think we can assume it'll be voted out Q1 of 26.
Voted out for.
We'll be ready to vote on it, to send it out for public comment.
Send it out for public comment, okay. At our January meeting?
That would be the hope, yeah.
April, okay, so it'd come back sometime in April, which means it would get back on our agenda on the May 1st COPRAC meeting. Okay, which is why I think I changed it to Q4 because it's going to be an opinion. Does the Q4 work? I feel like it's kind of hard to set deadlines when we don't know what all of the public comments are going to say. But I'll make sure that I include a note in here like we did for the 25 work plan, that it's dependent upon the public comment.
Right.
And whether changes are made. Okay, so is that one good?
Yes.
Next up is ethics of in-house counsel, business transactions with clients. Oh, this is the one where we were talking about there might end up being substantive changes to the 1.7 analysis. And if that was the case, it would need to go back out for public comment again.
Right. So it's either going to be out for public comment or voted to go to the board.
Okay.
Or January.
I'm going to edit this to Q1 or Q3 then.
Yeah.
Cryptocurrency. Do we have an idea of if it's going to be an alert versus an opinion?
I think, Eleanor, didn't we say we're gonna make it an alert? That crypto?
Yeah, crypto is going to be an alert and we should have something ready in January.
So that one does not.
You know what? Let's go with Q2 on that because given how controversial the topic has been there, let's just assume there's going to be more comment once the working group reviews it. So let's go with Q2 and hope for Q1.
Okay. And we do have time in Q1 since we have our March meeting and this doesn't require public comment. So I'll leave Q and get rid of this. Okay, so now we're into the ones that have not gone out for public comment at all. So this is ethics of in-house counsel, former clients, and IP.
And that one we hopefully will have next month to get voted out for public comment.
Okay, so I put Q4 of next year, given that it needs to go out for 60 to 90 days of public comment, and then we need to get it back.
I think that makes sense.
Okay. Attorney adjacent work and handling retainers and fees. This one, we're going to be getting the outline in January, so I put Q4 of 2026 or Q1 of 2027. Does that work? True? Okay. Our fee arb, ADA updating. This one obviously got a lot more complicated today. Should I modify this potentially Q1 of 2027?
Yeah.
I have the ethics alert as being Q1 2026. It doesn't have to go out for public comment, but depending upon where we land, the Office of General Counsel may need to review it. So I want to keep that in mind when we're talking about our deadlines. Should we keep Q1? Did you want to move it to Q2?
Yeah, let's move it to Q2 because of that. I mean, we should have, well, yeah, I mean, we should have it drafted by the January meeting, but as far as it being actually published, yeah, Q2.
And then for both artificial intelligence and civility, I just have TBD, just given that our working groups are still working on figuring out what the recommendations are going to be and how we're going to move those forward. If anyone would like me to add anything or put anything else in here, I can. Just let me know.
I think TBD is the right way to go.
Okay. Raquel, did you raise your hand?
I do have my hand raised, not for these, but for your comment of adding other things to this work plan. Is that fine? Are you at that point? I thought you were, but maybe you're not.
I think we are, because the only other thing on here is the ethics symposium. And that is it. Yeah.
Okay. I don't know if this goes on this working plan, but I would like the committee to talk about it. And I do think it's something that annually we should review. And that is the rubric and the process for selection of new members. So that sort of happens in the background, but the committee doesn't really have a, we don't have any involvement or even kind of know what the rubric is on how people are being selected. And one of the areas that I think we do need to consider is we no longer have anybody has arbitration experience on this committee, and the arbitration materials is folded into this committee. And so that is something we should be trying to get members on, but aside from that, just overall. So I think it would be effective to have that committee selection process rubric on our work plan annually, is my suggestion. And we have never had it because we've really never had the conversation. I think it happens probably with the chairs and the staff.
Yeah, and the rules regarding membership selection are in our COPRAC rules. And that it's, what is this, section 2, goes through all of the different factors and the process for that. So those are all in the COPRAC rules.
Okay. I still do think it's something the committee should talk about. Because I'm sure like I said, there's some nuances. We don't have an arbitration type of people on this committee for the last at least 2 years. They've dropped off, and we should be adding them, and we haven't. And I don't know if it's because, I don't know if it's just been an oversight or, so to me, it still seems like there are rules, but I do think as a committee, we should have some engagement around that. Unless there's some reason why it's only left to the chair and the staff.
No, I think in years past, it was essentially the request was for people to help identify candidates. And then staff did a vetting process, and then the chairs interviewed.
I'm also just curious why we would want to prioritize arbitration experience over other areas of expertise. Like what, Raquel, can you speak to that?
Because what was the committee that's folded into our committee now, which resulted in Novella and myself taking on an arbitration case. So the historical past is that whoever was working on the arbitration advisories, they decided when they did some kind of reorganization of the bar to fold that into this committee. And at the time, the reason they were able to do that is because they folded the people who were the arbitration experts into the committee along with the responsibility. Those people have now not on the committee. So this is the first advisory that we've had since those people are gone. And so we have a responsibility where we really don't have the expertise on this committee. And we should, because we have that responsibility. So I'm not prioritizing it over anything else other than to say we're supposed to be able to handle these with a certain level of expertise. That's the reason, which is a historic, it's something that the bar made the decision to fold that into this committee.
Cassidy.
I think that and I appreciate that, but I think that maybe you're misunderstanding the expertise or level of expertise necessary for those advisories. I think when you're talking about, I'm blanking on the names, they were part of the earlier committee, and I think maybe some of them had served as fee arbitrators, but a lot of us have fee arbitration experience. And, in representing clients in fee arbitration. So we certainly are familiar with the process, what the arbitrators are supposed to, what their standards are and what the purpose of the advisories are. So, but I just want to clarify that is that it's not sort of this like separate thing, is that a lot of the ethics attorneys on this committee do have that sort of fee arbitration experience that is, what you're talking about.
Appreciate that. So Rachel and everyone else, the nature of this conversation is what I'm saying we should be talking about, right? Because I'm saying, it seems like it's missing, and Cassidy's saying, oh no, it's not missing, we're fine. And so I'm just saying, if we have a committee, we have responsibility and we need to know who's coming on and who's not and what we should actually be looking for. That is beyond some rules, but based on what we have, what we think we need, what kind of people we need. Et cetera, et cetera. To include, my observation is, I think making it more clear that time outside of the meeting is really important and to be available, because I think that has become a real issue, is that people come and they're able to serve at the meeting, but they have very limited time outside the meeting, and most of the work takes place outside the meeting. And so all of these things I'm saying are the things that I think annually this committee should talk about and have some kind of framework as we're looking for people. it's not going to be the same every year because we're going to have a different composition of people as people come on and off. So, you know, this is what I'm advocating, that we move beyond the roles to sort of, this is what's going to be helpful. And so I think this is an example where, you know, Cassidy said, I take it and say, okay, I feel more comfortable now, based on what Cassidy said about that subject. Over.
I think it's a fair point. I would love to see more in-person meetings so we can actually meet. Like, for example, Allison, I don't think I've ever met you before. Maybe last meeting was your first meeting and I missed it, so I apologize. But I think Raquel makes a really good point, and I think it'd be nice for us to get to know each other a little bit better as well.
I agree. I think it, you know, an example is also the prosecutor experience, sort of analogous to the arbitrator experience. We have identified that that's very helpful for circumstances where we're assessing opinions that relate to criminal law issues and procedure. But I would support putting it on the work plan ahead of the process, where we just kind of discuss and address the types of goals that Raquel described and Cassidy, and suggest, because it's the first phase was always for members to identify potential colleagues that might be good candidates. It's a very good idea to have a discussion about certain types of expertise that we think that the committee wants. So, Rachel, can we put on the work plan something ahead of the process where candidates are identified so that the committee can take it up as a line item at the meeting on the agenda and just say, this is expertise that we believe we would benefit from in candidates. So if anybody knows of folks, it might be AI, it might be technical, you know, it could be at that level.
Yeah, so I'll just share my screen again so I can show you guys what I'm doing. I just added the topic COPRAC membership under committee operations and one-time assignments. And I will need to look up when our membership applications open for the next year. And then I can make sure that we agendize that before that membership application opens so that, yes, the committee can have that discussion.
I think that's a good idea. Yeah, thanks, Raquel and Cassidy and others.
And I think just given the number of changes I've made to this, and the things that we've moved around and added, my suggestion would be to have me clean this up and then email it out to the entire committee for review, and then we can put it on the January agenda. And in the meantime, because I know mostly what it's going to look like, I can work on the board item so that it will all be ready to go when the committee votes it out to the board at the January meeting, because this will be presented to the board in their February 19th to 20th meeting. So I think that timeline would work.
It sounds great to me. Thank you.
Perfect. Thank you.
Okay. New business. This is being presented by me. This is an opportunity for any member to identify something they'd like to agendize for the next meeting or the staff. Emil?
Sorry, I feel like I'm the only one talking for everything.
Feel free.
So I believe it was in September, Rachel had suggested that we have an ability now to opine in a limited circumstance on matters that potentially relate to UPL. So I'm hoping that I could suggest two things we can work on. And before we kind of officially talk about them, maybe Rachel, you can kind of give us some insight. But one is remote practice from within California, which right now we have one BASF opinion about that issue. And then two, last year, I believe it was, I'm blanking on that gentleman's name, but the one that is always on the moral character informal conferences. but he had given a presentation to ADDC about changes to the RIHC process for non-residents. So I guess if there is news about that, I think it'd be helpful to know, but I would also love to see if we can opine on what an in-house counsel for a California company that does not reside or work from California, what are they permitted to do? Sorry, that's a lot.
Yeah, this is actually perfect timing because staff is currently working on finalizing a memo to give to all of the COPRAC members specifically regarding the sunsetting of the prohibition that didn't allow us to work on UPL matters. So we can get that to the committee and then we can agendize it in January for discussion regarding UPL issues.
Thank you. But in terms of maybe just getting some thoughts though, or I guess we can't really talk about that unless we've agendized it. Okay,
Right.
yeah. So I'll be quiet now.
A similar question, I'll just chime in now, because a similar question came up in the AI working group where we wanted to know if, and our experts wanted to know if we can touch on AI, or rather UPL, and what the guardrails are there. So if you could reach out to us with any guardrails you can share, that would be useful.
You mean in the context of agentic AI practicing law?
That was how it came up. Yes. And were people using,
is that even possible
tools that
for
might
agentic
be
AI to do?
exactly, you view it as the person, but then
And I mean, maybe it goes back to what was the purpose of the prohibition? It's related to North Carolina dental, right? Like Sherman Act type stuff. So if that's the case, I mean, I think a lot of that has cooled down, and preventing, preventing these out-of-state actors is not really what we're opining on. We're opining on, what we think is permitted conduct, not what we think is not permitted conduct. I think that's the way I'm framing some of these things in my mind.
I would agree with that.
Okay, so we will
Glass
add
half full.
to the agenda for January so we can have a discussion about it.
Eleanor.
I am curious if there's anything we can do to educate the public about where to direct their complaints. I know that we tell them we don't handle that right now, but if there was some sort of a packet we could provide or an email we could send so that we are at least communicating, a path for these people who are coming to the committee and don't understand the committee is not empowered to assist.
I think that's a very good point. We have had obviously a lot of public comment related to things that aren't within our jurisdiction. It takes a lot of time and obviously energy. In some instances, they even reference that they have gone through the discipline process. So it's not clear that would help, but I don't think it would hurt.
If we could give them some sort of something that directs them to the appropriate process, I think it would be helpful, or other resources even.
Kathy.
Yeah, I think that that's a good idea, but I will note that these people, the people that particularly that gave public comments today, they give public comments in every committee's meeting pretty much. And so I'm not sure and up to the Board of Trustees. So I'm not sure that would, I'm just not sure how much that would actually help, but we can look and see what information is given around the public comment and the different branches or the different committees and what their responsibilities are, and see what the public outreach kind of strategy is around that and get back to you. But I will note that the public, the people that are, especially today, they tend to public comment in every meeting.
Yeah. Maybe it could be on our agenda under the public comment area too, just in case there were people who actually might not know where to pursue those claims. Okay, thank you for that. Other new business? Anyone from the committee or staff want to talk about some new thing? Moving on. The final one is 415, legislative advocacy. Rachel.
There is nothing to report since the legislature is not in session.
Ah, great. Okay. With that, we are adjourned. Thank you, everyone. Great job. Have a great weekend.
Thank you.
Thank you, everybody. Have a nice holiday.
Thank you. Thank you.